Muhammad Amir, Director, Kevin Judicial Academy. I welcome you all. So I start formally. Honorable Chief Guest, Mr. Justice Sajid Mansoori Shah, Senior Union Judge, Supreme Court of Pakistan. Honorable Judges of the Supreme Court of Pakistan. Honorable Chief Justices and Judges of the High Courts. Senator Mr. Adil Ravi Tawil, Federal Minister for Law and Justice, Government of Pakistan. Mr. Mansoor Usman Irwan, Government Attorney General for Pakistan. Mr. Mohammad Aurangzeb, Federal Minister for Finance, Revenue, Government of Pakistan. Barrister Nakeem Ali Khan, former Attorney General for Pakistan. Mr. Faisal Naqvi, Member Arbitration Law Review Committee. Barrister Toby Lindau, KC Advocate, Arbitrator at Duxton Hill Chambers, Singapore. He is with us on Zoom and may be available after a short while. Mr. Hayat Ali Shah, Director General, Federal Judicial Academy. Ms. Rifat Imam Bhatt, Secretary, Law and Justice Commission of Pakistan. Welcome members of District Judiciary and members of the bar and all the honorable guests. I welcome and assalamu alaikum. On behalf of Law and Justice Commission of Pakistan and the Federal Judicial Academy, for this one-day consultative workshop on rethinking and reshaping arbitration law in Pakistan, I request all the guests to kindly rise up for the national anthem. Thank you. Please have your seats. With permission of the Honorable Chair, the proceedings are to commence. With the recitation of the Holy Quran, I invite Hafiz Muhammad Mahmood from the Law and Justice Commission of Pakistan to kindly come on the rostrum and recite few verses from the Holy Quran. Hafiz Muhammad Mahmood.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم إن الله يأمركم أن تؤدوا الأمانات إلى أهلها وإذا حكمتم بين الناس أن تحكموا بالعدل إن الله نعم ما يعظكم به إن الله كان سميعا بصيرا صدق الله مولانا العظيم.
Jazakallah, Hafiz Sahab, thank you very much. Honorable Chair and the learned guests, why we are here and who will tell us that let me introduce a Fulbright Humphrey Fellow, an LM from University of Minnesota, an expert in public international law, a legal researcher with legislative drafting experience, formerly a lawyer, a judge, and a consultant with deep understanding of Pakistan's legal system, an author and contributor to various international reports and journals, a speaker at local and international training events on arbitration, justice, human rights, and terrorism. Principal Inamdar, the Secretary Law and Justice Commission of Pakistan, who has steered the current legislative initiative on the arbitration law review project from its inception till today. I invite her for the introductory remarks. Ms. Rita Inamdar.
Bismillahirrahmanirrahim. Honorable Mr. Justice Syed Cordially, Honorable Judges, High Court, distinguished Mr. and Attorney General, government officers, members of the board, fraternity, ladies and gentlemen, Assalamu alaikum. It is my great honor and privilege to welcome all of you to this momentous event organized under the auspices of Law and Justice Commission of Pakistan. This event marks a significant turning point in the journey towards the advancement of the arbitration regime in Pakistan. The proposed new legislative framework is robust and capable of coping with the emerging challenges in dispute settlement by providing an immediate environment that can keep pace with the changing business climate. The Law and Justice Commission of Pakistan, which is responsible for law reform, decided to review the Arbitration Act of 1940 with the aim to make it more relevant to the current needs of the business and investment trends and to address the issues highlighted in the judgments of superior courts. The Commission conducted thorough legal research to analyze the current legal framework in the country and to identify best practices from around the world. This was the initial groundwork for the review process. The Secretariat recognized the need for an efficient and enforceable arbitration framework in Pakistan, and to make this happen, the Arbitration Law Review Committee was formed by the then Chief Justice of Pakistan in April 2023. The committee was chaired by the Honorable Mr. Justice Syed Cordially and included representatives from various stakeholders and experts in the field. The committee meticulously reviewed the existing legislation and proposed comprehensive reforms to streamline the arbitration legal framework. The objective was to cater to the requirements of the fast-growing business and investment environment in Pakistan for dispute settlement. I am extremely pleased and grateful to the committee for their successful efforts. Through diligent collaboration and rigorous analysis of draft legislation, the Arbitration Bill 2024 has been developed. This bill incorporates international best practices and caters to the specific needs of our legal system. We are now ready to hand over the bill to the government. I would like to express my gratitude towards the committee members who provided invaluable assistance and support in shaping the proposed legislation. Each expert, including Mr. Makroom Ali Khan and Advocate Faisal Naqvi, contribute their expertise to this endeavor. The representative of the Ministry of Law and Justice, the Board of Investment, and the other co-opted members also provided valuable input and support. I would like to give special acknowledgement and gratitude to the Chairman of the Arbitration Law Review Committee, Mr. Justice Syed Shah, for his guidance during the review process. Thank you, sir, for your foresightedness. Also, without you, the Commission has not been able to achieve this target today. I express my gratitude to the visionaries who have provided unwavering support throughout the process, such as former Chief Justice of Pakistan, Mr. Justice Cordially, and the incumbent Chief Justice and Chairman of Law and Justice Commission, Mr. Justice Parveen. I would also like to acknowledge the efforts of our legal research team, especially Ms. Nadia Kramale, and the officers of the Secretariat for their consistent hard work and the professional approach in achieving this goal. Ladies and gentlemen, today I would like to emphasize our commitment to continuing to lead the arbitration law in Pakistan, ensuring they remain up to date and robust in line with the changing needs of the business environment in the region. The Commission will continue to engage with all the stakeholders and the government institutions to support relevant forums in expeditiously finalizing or processing the draft legislation. We aim to make Pakistan an attractive seat of arbitration for investors and businesses in the region. In summary, today's program will feature insightful views and discussion by the esteemed speakers, culminating in the formal handover of the arbitration bill 2024 to the Ministry of Land Justice. This marks a significant milestone in our ongoing efforts to modernize Pakistan arbitration framework. Thank you very much.
Thank you, ma'am, for the great insight as to why we are here and what we have to deliberate further. Now, a lawyer and then a judge in district judiciary whose career includes his serving as a registrar of the Peshawar High Court and a pioneer director general of the KP Judicial Academy, Mr. Hayat Ali Shah, who is now the director general of the Federal Judicial Academy. FTA focuses on judicial training and education of judges, magistrates, law officers, and court personnel to improve the quality of justice administered in courts. I request Mr. Hayat Ali Shah, the Director General of the Academy, to enlighten us as to how he sees the new bill on arbitration and the role of the Academy. Mr. Hayat Ali.
الحمدللہ رب العالمین والصلاة والسلام علی رسول اللہ. جناب جسٹس جناب اعظم وزیر طاہر صاحب، وفاقی وزیر قانون، وائس چیئرمین بورڈ آف گورننس فیڈرل جوڈیشل اکیڈمی، معزز جج صاحبان، خواتین اور حضرات، شہدائے کورس، محترم وفاقی زمین، فیڈرل جوڈیشل اکیڈمی کے لیے یہ آج نہایت خوشی کا موقع ہے اور ایک تاریخی دن ہے کہ ہم اس اہم دن کا حصہ بننے جا رہے ہیں جب پاکستان لا اینڈ جسٹس کمیشن ایک انتہائی اہم قانون کا مسودہ حکومت پاکستان کے حوالے کرنے جا رہا ہے. یہ مسودہ مجھے یقین ہے کہ انصاف کے اصول کو پاکستان میں آسان بنائے گا، جو ہر پاکستانی کی خواہش ہے اور جو ہر پاکستانی کا حق ہے. قانون جیسا بھی ہوگا اس کو عملی شکل عدالتیں دیں گی، اور عدالتیں عملی شکل اس وقت دیں گی جب وہ اس قانون کو سمجھیں گی. فیڈرل جوڈیشل اکیڈمی کا یہ مینڈیٹ ہے اور یہ ذمہ داری ہے کہ وہ ہر قانون، چاہے پرانا ہو چاہے نیا ہو، اس پہ اسٹیک ہولڈرز کی ٹریننگ کرواتا ہے. ہم اپنی مینڈیٹ کو اور اپنی رسپانسبلٹی کو محسوس کرتے ہیں، اور میں اس موقع پہ یہ کہنا چاہتا ہوں کہ انشاءاللہ اس نئے قانون پہ جس اسٹیک ہولڈرز کو جس قسم کی تربیت کی ضرورت ہوگی فیڈرل جوڈیشل اکیڈمی فراہم کرے گی. فیڈرل جوڈیشل اکیڈمی کی خوش قسمتی ہے کہ جہاں اسے چیف جسٹس آف پاکستان کی مکمل سرپرستی حاصل ہے، وہی جناب سید منصور علی شاہ جیسے ہمجہد شخصیت کے مالک کی رہنمائی بھی حاصل ہے. ان کی رہنمائی میں فیڈرل جوڈیشل اکیڈمی نے سالوں کا سفر مہینوں میں طے کیا ہے، اور وہ منزلیں جو قدم قدم چلتے بڑی دور نظر آ رہی تھی، یوں لگتا ہے جیسے خود چل کر فیڈرل جوڈیشل اکیڈمی کے قریب آنے لگی، اور وہ کسی شاعر کی خواہش تھی اور وہ یہاں عملاً ہوا کہ اے جذبہ دن گر میں چاہوں ہر چیز مقابل آ جائے، منزل کی طرف دو گام چلوں اور سامنے منزل آ جائے. اور وہ باقی یہی ہوا کہ فیڈرل جوڈیشل اکیڈمی نے جو سفر مہینوں میں طے کیا وہ کئی سال، ان کے لیے کئی سال درکار تھے. فیڈرل جوڈیشل اکیڈمی جہاں دنیا کی بہترین انسٹیٹیوشن اور اداروں کے ساتھ روابط بڑھانے میں کامیاب ہوئی. ان میں خصوصی طور پہ جن کا ذکر میں کرنا چاہوں گا وہی آکسفورڈ یونیورسٹی, یونیورسٹی آف نیو یارک یونیورسٹی, یونیورسٹی آف کیلیفورنیا, پیس یونیورسٹی یو ایس اے, ETH زیورچ. اور یہ میں آپ کو بتاؤں کہ یہ ساری باتیں ان سب اداروں کے ساتھ روابط بڑھانے کے لیے ہمیں نہ صرف حوصلہ دیا بلکہ ہماری مدد بھی کی جناب منصور علی شاہ صاحب نے. اور مجھے اگر وہ اجازت دیں میں معذرت کی چاہوں گا اگر مجھ سے کوئی گستاخی ہوئی, لیکن میرے ذہن میں برجستہ غالب کا وہ شعر آ رہا ہے کہ رگوں میں دوڑنے پھرنے کے ہم نہیں قائل, رگوں میں دوڑنے پھرنے کے ہم نہیں قائل, جو آنکھ ہی سے نہ ٹپکا تو پھر لہو کیا ہے. یہ مجھے لگتا ہے جناب منصور علی شاہ صاحب کا مشن ہے, اور اسی مشن کے ساتھ اسی جذبے کے ساتھ وہ ہمیں چلا رہے ہیں. اور ہمیں اپنی کیفیت یوں لگتی ہے جیسے کہ اسی کشمکش میں گزری میری زندگی کی شامیں, اسی کشمکش میں گزری میری زندگی کی شامیں, کبھی سوز و ساز رومی کبھی پیش و تاب راضی. اور اس جدوجہد کا نتیجہ یہ نکلا کہ فیڈرل جوڈیشل اکیڈمی جہاں آن ون ہینڈ ان اداروں تک پہنچی اور وہاں سے ہمیں اکیڈمک سپورٹ ملی, وہیں ہمیں ٹیکنیکل سپورٹ مختلف اداروں سے ملی جن میں بطور خاص قطر انٹرنیشنل کورٹ اینڈ ڈسپیوٹ ریزولوشن سینٹر جو اس وقت دنیا میں بڑا مشہور اور بڑا ایکٹیو ادارہ ہے اور جو یقیناً آج کے اس موضوع سے بڑا ریلیونٹ ہے, ہمیں ان کی سپورٹ حاصل ہے. ہمیں UN وومن کی سپورٹ حاصل ہے, ICRC کی سپورٹ حاصل ہے, ILO کی سپورٹ حاصل ہے, ILL کی سپورٹ حاصل ہے. فیڈرل جوڈیشل اکیڈمی کا جو ایجوکیشن پروگرام ہے ہمارا 2024 جسے ہم FJET کہتے ہیں, اس کے تحت فیڈرل جوڈیشل اکیڈمی جہاں روزمرہ کے عدالتی امور کے ساتھ کو ڈیل کرتی ہے, یعنی ان کے مختلف موضوعات دیوانی, فوجداری, ریونیو, ان موضوعات پہ جہاں ٹریننگ مہیا کرتی ہے, وہیں عام ICT سے لے کر آرٹیفیشل انٹیلیجنس تک کے تمام ایریاز کو کور کرتی ہے. ایموشنل انٹیلیجنس سے لے کر انٹیگریٹی مینجمنٹ تک اور میڈیشن سے لے کر انٹرنیشنل آربیٹریشن تک کے تمام موضوعات فیڈرل جوڈیشل اکیڈمی کے کیلنڈر میں شامل ہیں. اور یہ میرا خیال ہے کہ فیڈرل جوڈیشل اکیڈمی کی ایک بہت بڑی اچیومنٹ ہے. اگر مجھے تو یہ کہا گیا تھا کہ میرے آج کے آربیٹریشن ایکٹ پہ کہ میرے خیال میں آربیٹریشن ایکٹ کیا ہے اس پہ بات کرتا ہے, لیکن چونکہ اس پہ بہت سارے معزز اور انتہائی قابل لوگوں نے بات کرنی ہے تو میں نے اس پہ بات کرنے سے زیادہ ترجیح اس بات کو دی کہ میں یہ بتاؤں کہ فیڈرل جوڈیشل اکیڈمی کیا کر رہی ہے, فیڈرل جوڈیشل اکیڈمی کیا کر سکتی ہے, اور یہ کہ جہاں ارادہ اور نیت, کمٹمنٹ اور ول دونوں مل جائیں تو وہ اس طرح کے ادارے بنا لیتی ہیں جس طرح کے فیڈرل جوڈیشل اکیڈمی ہے. میں آپ سب لوگوں کو فیڈرل جوڈیشل اکیڈمی آمد پر خوش آمدید کہتا ہوں. میں لا اینڈ جسٹس کمیشن کو مبارکباد دیتا ہوں کہ وہ ایک انتہائی اہم قانون کا مسودہ آج قانون بنانے کے لیے حکومت کے سپرد کرے گا, اور میری دعا ہے اور میری خواہش ہے کہ اللہ کرے کہ یہ قانون پاکستان میں انصاف کے حصول کی آسانیوں میں مددگار. جزاک اللہ. تھینک یو.
آپ کا سر بہت بہت شکریہ. آپ نے ایک تو قومی زبان پہ بات کیا کہ میرے دوست کو انگلش میں اس لیے میں انگلش بولنے کو مجبور ہوں تھوڑا سا, تو لیکن مجھے کہ اور یہ پتہ ہی ہوا کہ فیڈرل جوڈیشل اکیڈمی کے لیے سارا ریفارم آپ لے کے آنا چاہ رہے ہیں, الٹیمیٹلی جب تک ٹریننگ نہیں ہوتی تو وہ ریفارم کو شاید آگے اٹھانا لے کے جا سکیں. تو تھینک یو ویری مچ سر ونس اگین. Now I introduce our next speaker, a graduate from Princeton University and Yale Law School, a partner in Bhandari, Lucknow and Riaz, a leading Pakistani law firm, Mr. Faisal Lucknow. He has extensive international arbitration experience both as a counsel and as an arbitrator. He has represented Pakistan in working group 2 of UNCITRAL and is a member of several international arbitration panels, including the panel of the Singapore International Arbitration Center, the Hong Kong International Arbitration Center, and the Asian International Arbitration Center. He was also counsel for Pakistan against India in relation to disputes arising under the Indus Water Treaty 1960. He was also appointed by the Independent Permanent Human Rights Commission of the Organization of Islamic Countries to prepare a report on whether international law prohibits the use of standard guns for crowd control. I invite Mr. Faisal Qureshi, Faisal Naqvi, Advocate Supreme Court and member of the Arbitration Law Review Committee for an overview of the draft legislation of the Arbitration Bill 2024. Mr. Faisal Naqvi.
Honorable judges, distinguished guests, fellow members of the legal community, Assalamu alaikum. I want to begin first of all by thanking Mr. Justice Cordially for entrusting me with the responsibility of acting as the principal draftsman. It has been an honor and a privilege to work with him and other members of the committee. But I'd like to note that this draft is a collaborative effort. All members of the committee have contributed to discussions and suggestions, and two people in particular I'd like to recognize. One is my partner, Nia Samruti, and the other is Mr. Zafar Khokan, who was seconded to the committee by Mr. Justice Cordially Shah, who helped greatly in the review of the law. Let me start by asking a very basic question. Why does commercial dispute resolution matter? Because in Pakistan, with great respect to all of the judges here, I won't go so far as to say that commercial dispute resolution is an exercise in futility, but as Dr. Johnson once said in a different context, it represents the triumph of hope over experience. People quite often choose not to go to court because they don't expect justice in any reasonable period. Many large businesses will simply write off amounts. Well, I'm just talking, this is commercial, normal commercial practice. 3 million, 4 million, 5 million people say we don't want to go to court. And where people don't feel that they can get justice in any reasonable amount of time, they will not invest because they will see it as too risky. And if they don't invest in businesses, then Pakistan doesn't grow, and that is something that affects all of us. So a functional commercial dispute resolution system, of which arbitration is an integral part, is very, very important. Let me move on to the next question. What is wrong with the 1940 Act? There's an Indian judge in 1976 who wrote about the 1940 Act that it makes lawyers laugh and philosophers weep. They changed the law in 1996. It's taken us slightly longer to get to the same point. So let me specify what the issue is. We start with the proceedings. It's very easy to say that you have waived the right to arbitration with different interpretation of what constitutes a step in proceedings. In some cases, even a request for an adjournment has been deemed a step in proceedings. We quite often have a deadlock between two different umpires, between two different appointments. So each party appoints an arbitrator. Each arbitrator represents only his party. You wind up with a deadlock, then an umpire, and considerable delay. Arbitrators, as we have all seen, are very fond of procedural, applying the full procedural rigor of the CPC and the QSO. The tribunal itself has very limited powers. There are multiple opportunities for judicial intervention, and the ultimate award is subject to review by a civil court. You have a situation where you have, let's say, former Chief Justice of Pakistan and other judges. Sometimes they don't want to act with these proceedings because they think it's inappropriate for their award to go back to the civil court to start afresh. And even if that is not a valid point, we know how civil courts operate. The word, the commercial perspective, and I'm talking commercial perspective, is that arbitration is civil court litigation with one extra layer added. That is why people quite often don't go for arbitration. So when you have this sort of a situation, how do you approach drafting? Now there is a model law. The simplest way is to you download it, you press F12, which is same as on your computer. और उसके बाद आप जिधर country का नाम है उसको बदल के आप पाकिस्तान कहते हैं, that's the end of it. But we tried not to do that. Because even before we got to the formal drafting stage, there were basic questions to ask. Do you agree Do you include mediation? Well, not in this case because hopefully there'll be a separate law. Do you include foreign arbitration? No, because we already have the 2011 Act, which is doing your job. You make it a provincial law or a federal law because in Pakistan legislative competence is split. Foreign arbitration, international arbitration is federal, domestic is entirely provincial. The solution, because we want a nationwide law, is to have hopefully resolution from the provinces, and then you will have one law all the way across Pakistan. How do you draft it? You draft it like Hong Kong or Singapore. You make it legislation by reference, but you make it all inclusive. I told them all inclusive approach. So these are all different choices that were made even before you started. And when we started drafting, yes, the model law and the Arbitration Act of India in 1996 were the primary sources. But to go beyond that, we also continuously made reference to the arbitration laws of other countries, in particular the United Kingdom, Malaysia, and Singapore, because these are common law countries whose jurisprudence we can use. So the beauty of the modern law is you can start from one place, different people have looked at different issues, and you can take the best of what the world has to offer. Before I go through an elaboration of what makes this law different and better, let me try and give an analogy. Justice Mansoor Ali Shah a few days ago talked about commercial dispute resolution. He talked about a commercial corridor. Let me suppose that we think of it as a journey from point A to point B. In that context, the 1940 Act is the equivalent of the GTO. मतलब कि बसेस भी हैं, गाड़ियाँ भी हैं, साइकिलें भी हैं, मोटरसाइकिल भी है, रेड़े भी हैं, रिक्शे भी हैं, टेलीविजन भी हैं, और आधे जो हैं वो उल्टी तौर पे हैं. The 2024 Act, I'm going to continue that analogy, is the equivalent of the general bus service. It's segregated. It's not necessarily that the machine which is traveling is quicker, but there is less opportunity for interference, less room for people to cross, and pedestrians have to go to specific places to interfere. So, if that analogy is simplified, there is less opportunity to interfere. It just follows world best practices. Speaking of judicial interference, and now I come to the specifics, Section 6 of the new law expressly says that courts will not interfere except as expressly provided. That is one of the fundamental points. We do not want judicial interference here. People are making their choices. And when they make their choices, they will have to live with the consequences subject to obviously judicial oversight as per international norms. The second difference that I can refer to is how do you start this process? What type of scrutiny arises on day one? So, the standard which has been set up is that so long as the arbitration clause is prima facie valid, unless you look at it, this is impossible. This cannot be. Everything goes to arbitration. And in terms of when are you deemed to have waived your right to arbitration, if you haven't filed a written statement, give or take, because the actual language is a reading of the substance of the case, but short of a written statement, you should be open to difficult to waive. Now, along with that, which is to say, if you say, well, maybe the arbitration clause is potentially not valid, one of the things that is in there is that this incorporates the international doctrine of separability and competence. What this means is that if you're saying that the arbitration, the agreement overall, somebody tricked me and not been able to cross, it will go to the arbitral tribunal because it has the competence. Even if the overall agreement is invalid, the arbitration clause is separate.
वही दिखा रहा
So
हूँ
you
मैडम,
still
वही
have
दिखा
that
रहा हूँ, आप
power
मेरा
to look
स्क्रीनशॉट
at
तो
what
देखें.
happened. So all of these arguments can be dealt with by the tribunal
ये
and it
लाइट
can
चल रहा है.
give a decision on that basis. One of the things which is different about this law from the ancestral model law is that we don't have one layer of code. To continue the analogy that I had about the general bus service in a way, there is a general bus service lane and there is also a motor lane. So we have defined we have used the phrase competent court. For what we have called international commercial arbitration, the competent court will be the High Court. And the term commercial, again, this is how we have localized it. In terms of defining what constitutes commercial, we have taken language from the ancestral model law. But we've also considered notification by the Singh High Court, which deals with what constitutes commercial, because this case was at that time. And again, because the Singh High Court judges have shown that they're quite concerned about getting too many cases, the High Courts have the power to say the only cases above a certain level will go to them, which we can change from time to time. So today we say, that the bare minimum is 50 million, tomorrow they can say 100 million, whatever allows them to deal with that level of cases. And all other matters go to district court. Nothing goes to the civil court anymore. District courts, in my view, represent an underutilized layer of the Pakistani judiciary. These are judges with sophistication and experience. They can be brought up to speed on arbitral developments. And I think if we make the focus of arbitration the district courts along with the high courts, that will be one of the main ways in which this law will provide or allow, justice to be provided to people. Another innovation in this law is the introduction of what we call the seat doctrine. Now, seat doctrine normally applies in the context of foreign arbitration. We'll have, say, London as the seat or Paris as the seat. In Pakistan right now, if you want arbitration, you say, hearing to be held in Lahore. Even if you specify that, you can go initiate proceedings in a different location. And then you have this problem where you can go to, let's say, Civil Court Shahpura, and you'll have proceedings somewhere else, and there's a continuous, people use this. There is a first mover advantage under the 1940 Act, which people sometimes abuse. And what we have done is that we have put in this law that if the parties have said that the proceedings and the seat will be Karachi, then you will go to the courts in Karachi to get relief. You get a stay wherever it's pending, but for all of the supervisory, the criminal court will be in Karachi. So this gets rid of also the seat versus venue debate, which is slightly technical here. But the reason why I mention is because in the famous case of Rupali, which you may know, which is Rupali polyester versus Hitachi, $200 million case back in 1998. That case started from Civil Court Shahpura. We would like to avoid that in the future. Now, in terms of what can go to arbitration, it is difficult to define arbitrability. So what we have done instead is that anything which is not contrary to public policy can be arbitrated. Let the courts work out the exact details. But one of the points which has been put in there is that real estate contracts, as long as they don't involve third-party rights, can also be arbitrated. A different issue which arises is in relation to the appointment of arbitrators. Now, what we would like in the future is for us to have institutional appointments, but till that time, and my colleague Samiti will be elaborating on that, is that the power to appoint lies with the High Court, and it has then been further delegated to arbitration councils which have been created under model regulations. So if a particular High Court doesn't like the regulation, it can change it, but on day one, you will have a basis for appointment structure because we don't want courts to be inundated with appointment requests. And something else which has been done right now in Pakistan, you don't have arbitrators are really subject to conflict of interest in express terms. We have taken the IPA guidelines on conflict of interest, the International Bar Association guidelines, simplified them and put them in the form of a schedule and say, if you want to be an arbitrator, you have to say, these are my relationships, these are the cases that I've done, so that you are then not subject to allegations of bias. However, next point, if there is an allegation of bias, if there is a challenge, the challenge will be heard by the arbitrator himself. There is no appeal provided. So this is very deliberate. If you have a setup that an arbitrator says, I don't consider myself biased, and then you have an appeal to a court, then the entire process will stop. What we want is for the process to continue, for the final award to come down, and then if the challenge has been rejected, the party concerned can say, look, I challenge him as being biased or him or her as being biased. In fact, that's one of the other things. This was a comment received. On the initial draft we had used, as we do in drafting language, him. And somebody said, this is what we hear. So all of the language has been made gender neutral, and I'm glad we did that, and I hope that comes through later on. But if the award is subsequently set aside on the same ground, the arbitrator can have his fee reduced. You may even be then told that, sorry, you have to give your money back. One of the main changes in this law is that the arbitral tribunal has been empowered. So if you go to arbitration, You can ask the arbitral tribunal to give a stay, to ask the other party to produce documents, to preserve the list, to make this whole law functional. You don't have to go back to courts the whole time. For within lawyers, there is a special provision regarding admiralty proceeding. And another thing is that even if you go originally to, let's say, the competent court and get a stay order, there is a provision that if you get initial relief, you have to start arbitration proceedings within 90 days, and then the arbitral tribunal is competent to modify that order. So, I mean, there is a case pending in the High Court, I don't want to name, where there was a stay granted against my client, and it's been 2 years and I haven't had a subsequent hearing. I can't even argue the interim relief, that will be a appointment issue. That hopefully will stop. More importantly, so the arbitral tribunal can pass an original order. If that is not complied with, it can then pass what's called a peremptory order, which is like do this or else. And there are consequences. Cases can be dismissed. They can draw adverse inferences. So if you don't produce evidence, they can say, sorry, we asked you to give you a peremptory order, you didn't do it. That means you don't have this evidence. And one final thing. Under the current law, if you have an international arbitration and you need interim relief, in my view, there isn't really a solution. The 2011 Act is unclear, and you don't really want the 1940 Act to apply to international arbitration. Now, if there is a foreign arbitration, you can get interim relief in support of foreign arbitration. At the procedural level, we have tried to simplify things. One of the things which has been done, and this follows in part from a study done of the Sindh High Court, the average, this is by Mr. Shahid Kardar in 2000, it is even worse now. The average time frame for a commercial case in the Sindh High Court is 118 months. I think more than 80% of that time was taken up by evidence. So what this law provides is that the evidence in chief of witnesses has to be given in written form unless parties agree to the contrary, and then you cross-examine them. And what we hope in the future is that the institution which arise will allow modern arbitral techniques or evidentiary techniques. When you ask questions, you get an answer, somebody records it, and through artificial intelligence, you get a transcript. Currently, as we all know judges, somebody asks a question, somebody gives an answer, and the judge says that we take something, then both lawyers object, then the witness realizes he said something wrong, then he changes his mind, and then you have another round of argument. So modern evidence, the way to record it, will also use technology hopefully in the future, will be something that will be crucial to the success of this law. And simplified evidentiary rules, simplified procedural rules are being prepared. But to give you a minor example of how efficiency can be raised, there is an express provision for concurrent hearings and consolidation of proceedings like we have in international cases. Other sort of modern developments. There is an express immunity provision. So if an arbitrator does something in good faith, you can't sue him for that afterwards. There is a confidentiality provision. Confidentiality is a difficult topic in international arbitration because there is a whole range. England has nothing on confidentiality. They have just developed doctrine. And if you go to the other extreme in New Zealand, they have 2 pages of provision as to what the court should do. We thought about which provision to adopt, and our confidentiality provision is taken from the LCIA rules and focuses on protection of the arbitral process. And we were thinking of maybe extending that to judicial proceedings, but I say that with great respect. I discussed it with other lawyers, and somebody said to me, "Sir, either to Supreme Judicial Council की proceeding confidential नहीं रहती, आप हम अदालत की proceedings को कहाँ confidential करेंगे?" So every law has to take into account local facts. We can't just simply assume. It's like trying to drive a Ferrari on the GT road. You won't go very fast. You hit something very quickly. So we try to make things reasonable. At the technical level, if those of you are interested in sort of this kind of minutia, there is something called the Enka versus Tubb case in the UK, which is as to when is the law of the arbitration agreement different from the law of the parent contract. There is a specific provision to deal with it. We've taken a different view from that to the proposed amendment for various reasons. Different point. There is a time limit provided for domestic arbitration of 18 months. The 1940 Act says 4 months. And lots of people voted to say, "Hi, you don't get an award in 4 months." You don't get it in 12 months. If you actually get it in 18 months, which is a reasonable thing, that would be great. So it's better to have a realistic time limit rather than to have an unrealistic limit which then requires you to keep on going back to court. For international commercial arbitration, which is where we expect more sophisticated parties and institutional arbitration, normally the time limit will be provided by the rules of the arbitral institution. The arbitrator has been specifically empowered to push for settlement. Again, this was the topic of criticism. पुराने कानून में तो इस तरह नहीं था. And our point is that modern practice recognizes that an arbitrator can encourage settlement. You can't go beyond that, as long as the neutrality is not compromised. Encouraging settlement and saying, देखिए आप कर रहे हैं, otherwise there will be consequences. It's very normal practice now. A different innovation that we're introducing is a cost regime, a formal cost regime. The 1940 Act recognizes cost, but it's not there in normal practice. Again, यहाँ पे domestic और international में हमें थोड़ा सा फर्क डाला है. कि domestic जो ordinary जो होगा उसके लिए कहना कि भी costs follow the event, जिस तरह इंग्लैंड में होता है कि आप दूसरों के पैसे भी दें, वो जरा मुश्किल है. But international commercial arbitration में ये कहना कि अगर आप हार गए तो आप दूसरे के पैसे भी देंगे, is reasonable, so there is a distinction there. Let me add one thing about the distinction between domestic and international commercial arbitration. International commercial arbitration has been defined in very clear terms. It's if there are rules of an international arbitral institution, if one of the parties is from a different country, if the substantive law is foreign, and this is the important part. If the parties have agreed it's international commercial arbitration. So yes, some parties in Pakistan are sophisticated now. If you have an Anglo versus ICI case, they will say we want it dealt with as an international commercial arbitration because we want to go to the High Court immediately when we have hopefully more sophisticated judges and with less ability to review. So we have to accommodate this spectrum of users, starting from very basic users to the most sophisticated users. What happens to the actual award? As we all know, in Pakistan currently under the 1940 Act, awards can be challenged on a multitude of grounds. Doesn't matter what ground it is, as long as we challenge it, it's not enforceable in effect until it's made rule of the court. Over here, first of all, the grounds for challenge are very limited. You cannot say, just because you got it wrong, therefore it is to be set aside. But again, there is a distinction between domestic and international. Domestic arbitration में गुंजाइश है for setting aside an award essentially of the equivalent of review jurisdiction. Patent illegality apparent on the face of the award. That's not there for international. International में उस level की भी गलती हो जाए, you cannot set it aside. The second aspect of that is, if time passes and there is no stay, the award becomes automatically enforceable. And if you want to get a stay, it's dealt with like a money degree. So the language in India uses money degree. What we have said instead is you need to deposit the money. Whatever is found, you deposit the money so that there is security going forward, except in exceptional cases. What those exceptional cases are will be, I think, elaborated by the courts on a case-to-case basis. But just to make sure that this point gets across, there is first saying this is not going to be stayed, and then secondly, it's written, even if you file an application, this is not a stay. So that the message in this instance is very, very clear. If you want to stay the operation of an award, other than in exceptional cases, please deposit the money. The issue of institutional arbitration is really, really important. My colleague Mr. Sami will speak about that. I just want to end by saying that this doesn't mean that this law, our contributions or our job is over. First of all, we hope there will be coordination between the ALRC and the Ministry of Law during the parliamentary process. I believe that Sisha has also mentioned separately the possibility of an international arbitration center in Islamabad. There will be training for judges. And then one last thing we're still working on, which is that along with, this is not just the law, there is also, like the Law Commission is supposed to, there is a report which is currently in draft form, which will say, we made this choice for this reason. It may be a good choice or bad choice, but tomorrow as judges, as lawyers, we will say, okay, this provision came from Singapore, this provision came from Malaysia, this was a policy decision, so that if you want to set it aside or understand it, that report will be there as a basic material for people to look at. And with that, I hand over to Yasamudin.
Bismillahirrahmanirrahim. Honorable Justice Mansoor Ali Shah, Honorable Judges of the High Court, learned members of the Judiciary, learned Attorney General, Honorable Ministers, distinguished guests, ladies and gentlemen, Assalamu alaikum. I'm grateful for this opportunity to give a brief overview of what is a small part of the Bill 2024, but is a very important part, and that is institutional arbitration. It is that part that lays the groundwork for institutional arbitration over ad hoc arbitration, which has been the prevalent form of arbitration practice in Pakistan. Now, before I go into the details on the distinction between the two, just to set out what the bill does in this respect. There are three things that the bill does. Firstly, it allows the High Court to delegate its power or function to make appointment of arbitrators to an appointing authority. And this is consistent with the Ustral model law and across the globe. And the point for this is because appointment of arbitrators is essentially an administrative function. It is not a judicial function. Secondly, this bill grants power to each provincial high court and the Islamabad High Court to make regulations consistent with the Act. And thirdly, in Schedule 2, the bill provides model regulations for each high court to adopt from day one, with obviously the freedom to change and modify the regulations. These model regulations, when notified by the Chief Justices of each high court, will establish an arbitration council, which Mr. Naqvi alluded to. Now, these arbitration councils will have independent members. They'll be associated with each high court, but run independently. Such arbitration council under the bill will, number one, have the power to make appointments of arbitrators. It will have the power to make procedural regulations which will govern the arbitral proceedings and even administer arbitral proceedings. These things lie at the heart of institutional arbitration. Now, why is this needed in Pakistan, and why did we feel the need to do this? This is an innovation. Ustral model law is agnostic to this, and the main reason is institutional arbitration is a type of arbitration where a specialized institution plays the role of administering it. Think of it as a hand-holding method of running the entire arbitral process from start to finish. And many would have heard of famous institutions such as the London Court of International Arbitration, the International Chamber of Commerce Court of Arbitration, and the Singapore International Arbitration Center. In other words, such institutions make arbitration more efficient and ensure that the entire arbitration process benefits the parties, as opposed to making the entire process a self-defeating exercise. Under the bill, where the parties have not agreed in advance to an institutional arbitration, such as the rules of the LCIA or ICC, the default choice will be that they have chosen the rules of the Arbitration Council. Under the present regime, the 1940 Act, where parties have not chosen any rules, the arbitration runs ad hoc. Now, what is ad hoc? Ad hoc simply means that the arbitrator and the parties have to figure it out for themselves. Where to hold the hearing, what procedure to follow. And any arbitration practitioner will tell you that it has often left the entire arbitral proceedings no better than court proceedings where commercial disputes are dragged out for many, many years. Now, as explained, the bill will resolve these issues by laying down a framework for institutional arbitration through the creation of these arbitration councils. If any party has not chosen in advance the rules of arbitration, then it will be deemed to have chosen the rules of the Court Associated Arbitration Council. This lays the foundation for institutional arbitration in Pakistan. Now, before I end, further want to highlight some long-term benefits for laying down this foundation. Institutional arbitration creates an opportunity for officially documenting and monitoring arbitration in Pakistan. And that allows meaningful improvements in the system for the future. A more formal system creates both local and foreign investor confidence because they can see arbitration happening in Pakistan. The foundation that will be laid down in the bill can be followed by the development of arbitration-related infrastructure, just as we heard that there's a possibility of having an Islamabad International Arbitration Center. This also allows such centers to perhaps even house the arbitration councils that are associated with the high courts. This also allows the adoption of new technology in private dispute resolution when the entire process is more formalized. In fact, the use of artificial intelligence technology is being discussed in international arbitration circles. This is especially relevant for the types of disputes that we are seeing internationally, maybe not in Pakistan, involves new technologies such as blockchain transactions. Now, Pakistan has some catching up to do, but hopefully it is our view that when the bill lays down this foundation for institutional arbitration, this would be the first step in creating a more formal and trustworthy process of private dispute resolution practice which matches international standards. Thank you for this opportunity.
Thank you very much, Mr. Faisal Naqvi and Mr. Sami, for telling us that how this law is actually drafted. Now I introduce our next speaker. He is Senior Advocate Supreme Court, a former Attorney General of Pakistan, a former Chairman Pakistan Bar Council, former member of Law and Justice Commission, former board member of the Federal Judicial Academy, and a former board member of the Sindh Judicial Academy, Mr. Mahmood Ali Khan, a serving member on the governing board of the British Pakistan Law Council, an officer of the board of the Forum for International Conciliation and Arbitration, a member of the board of trustees of the Dubai International Arbitration Center, a member of the advisory board of the Citizen Police Liaison Committee, a former member of the London Court of International Arbitration, and a member of the International Center for Settlement of Investment Disputes, ICSID. ICSID Chairman's Panel of Arbitrators. Now I have the honor to invite Barrister Mahmood Ali Khan for his valuable remarks.
Moses Judge Sahiban, Excellencies, my reading poor and can't translate excellencies included. Ladies and gentlemen, हुक्म है कि बात उर्दू में की जाए, तो उर्दू से शुरू करता हूँ। शुरू की चंद बातें आज़ाद तर्जुमा है उस गुफ्तगू का जो अंग्रेजी में सोची, तो जो इसमें गलतियाँ हो उनको माफ़ कर दीजिएगा। इस गुफ्तगू की हैसियत कुछ उसी तरह की है जैसे गज़ल वो शुअरा की नज़र में नस्री नज़म की। सर, सवाल पैदा ये होता है कि एक मुल्क में जहाँ पे अगर किसी चीज़ की इफरात है तो वो क़वानीन की है, तो उसमें एक मज़ीद नया कानून क्यों? इसकी चंद वजूहात हैं। दुनिया भर में ही नहीं बल्कि इस खित्ते में भी हर मुल्क में अपने कानूनी पॉलिसी में तरामीम की बड़ी हद तक और अक्सर बेशतर में उसको असर में तब्दील कर दिया। वो सब के सब हमसे अब कोई 28-30 साल आगे हैं। हम इन मामलात में शुरू में पेश थे। 1958 में जब न्यूयॉर्क का मायदा हुआ
تو پاکستان ان چند ملکوں میں سے تھا جس نے اس پہ سب سے پہلے دستخط کی. 1966 میں جب معاہدہ واشنگٹن ہوا تو ہم پھر ان چند ملکوں میں تھے جنہوں نے ان پہ سب سے پہلے دستخط کیا. اس کے بعد توثیق کرنے میں ان کے بہت وقت لگا، معاملات التوا کا شکار ہو گئے، یہاں تک کہ ایک جو معزز مصنف بھی تھے انتقال ہو گیا ان کا حال ہی میں، اور انہوں نے بہت سی کتابیں بھی لکھی ہیں، عالمانہ کتابیں لکھی ہیں، بین الاقوامی ثالثی کی اور ثالثی پہ امام الغایا نے. انہوں نے اپنی کتاب میں کہا کہ پاکستان آربیٹریشن کے معاملات میں جو اس میں بین الاقوامی معاہدے ہوئے ہیں ان کی مسلسل خلاف ورزی کی جا رہا ہے. یہ پھر جو انحراف تھا اس میں ہم نے تھوڑی سی تبدیلی کی. 2005 کے قریب توثیق کی معاہدہ واشنگٹن کی بھی، معاہدہ نیو یارک کی بھی. لیکن اس الزام سے تو ہم بری ہو گئے، لیکن قانون جو بنانا تھا، جو ہمارے قانون کو بین الاقوامی قوانین کی سخت میں لا کر کھڑا کرتے، اس میں کافی دیر ہوئی. ایک بات جو میں عرض کروں، بہت سی باتیں کی جاتی ہیں کہ یہ قانون کیوں، یہ تو مغرب یہی چاہتا ہے، دس از واٹ دا ویسٹ وانٹس. تو آپ صرف اس معاملے میں ان کی تقلید کر رہے ہیں، آنکھیں بند کر کے ان کے پیچھے چل کھڑے ہوئے. لیکن آج کل کے جو حالات ہیں اس میں ایک بات بالکل واضح ہے کہ اگر آپ کو بین الاقوامی تجارت کامیابی کے ساتھ کرنی ہے، اگر آپ چاہتے ہیں کہ اس ملک میں بین الاقوامی انویسٹمنٹ ہو، تو وہ ایک جدید آربیٹریشن کے ثالثی کے قانون کے بغیر ممکن نہیں. بار بار یہ کہا جاتا ہے بین الاقوامی سطح پر کہ آربیٹریشن از دی انجن آف ماڈرن فائنانس. اب اگر آپ کے پاس نیا قانون نہیں ہوگا، جدید قانون نہیں ہوگا، تو یہ تو نہیں ہے کہ تجارت نہیں ہوگی بین الاقوامی سطح پر، یا یہ نہیں ہے کہ سرمایہ کاری نہیں ہوگی پاکستان میں، لیکن اس کی حیثیت ایسی ہی ہوگی جیسے ایک گاڑی کی بغیر انجن کو ہوتی ہے، اس میں وہی سارے سکون رہ جائیں. اس قانون کی جو خوبیاں ہیں وہ فیصل نقوی صاحب نے بیان کر دی ہیں. انہوں نے ذکر بھی کیا اور بجا طور پر ذکر کیا میاں سلیم الدین صاحب کا، ظفر کھوکر صاحب کا، جنہوں نے اس سلسلے میں ان کی بہت بیانت کی، معاونت کی. جسٹس سید منصور شاہ کی سرپرستی انہیں حاصل رہی، اور یہ اس سب کا سمجھ ہے. خوبیاں انہوں نے دلوا دی، لیکن تھوڑے سے مسائل رہتے ہیں اور رہیں گے. ان میں سے کچھ کی میں نشاندہی کرتا چلوں. اور جیسے کہ کہتے ہیں اس قانون کے آ جانے کے بعد، اس کے لکھے جانے کے بعد اگر یہ پارلیمنٹ سے پاس ہو بھی گیا تو اٹ ول ناٹ بی دی اینڈ. And as a famous quote goes, it will not even be the beginning of the end. It will be the end of the beginning. The real test will come thereafter. And why do I say the real test? I say a real test because there's an old theatrical saying, common in theatrical circles, that a play does not exist till it has been performed on a stage before a live audience. A law does not really exist till it has been tested in the crucible of litigation and has been scrutinized by the judges. Now, that being the case, what is the reason for this law to fall short? A lot will depend upon how it is interpreted. It has been said and said repeatedly that there is enough room in sections 32 and section 33 of the old Arbitration Act of 1940 for the doctrine of separability to be enunciated as a principle. But it did not succeed there. There have been some bold and valiant efforts like Lakha, but they are voices in the wilderness. There was enough room to virtually do away with the doctrine of concurrent fusion jurisdiction. But it received its variant only recently when my Lord Justice Mansoor Ali Shah, presiding over the bench of the Supreme Court, upheld the judgment of the Lahore High Court, holding that this theory is no longer good law and moved the law forward. Now, the approach has to be both judicial and governmental. And it is on these twin approaches that the determination of the success and failure of this law will depend. Now, we look at, when we look at this law, we find that there are sections 39 to 41, and those are the sections which I will focus on. These are the sections which relate to the enforcement of awards. This is where the courts will come in. How quickly they enforce these awards and how effectively they enforce these awards will determine the success or failure of this law. Like every law, this law has words which are open-ended. It is inevitable. If you do not have open-ended words, it hamstrings the approach of the litigators, the legislators, and interpretation by the judges. So this law still has words like fraud, like corruption, like illegality, which will fall to be interpreted by the judges when it comes to enforcing or refusing the enforcement of these awards. I mention these words particularly because we live in a country where these words are freely bandied about, given all kinds of nuances, given all kinds of meaning. The judicial interpretation has to move away from that. No less important will be the speed of decision making. I mentioned Justice Amsha Malik's judgment in the Lahore High Court upheld by Lord Justice Mansoor Ali Shah in the Supreme Court. Now, if you look at the timeline, you will see that between the time when this case started in the civil court and the final judgment of the Supreme Court, it has taken 12 and a half years. And is that the end? No. This judgment has only determined that the 2011 Act applies and not the 1940 Act. Now enforcement proceedings will start under the 2011, and they will have a life of their own. And when they are over, execution proceedings will start, and they too will have a life of their own. And as the Privy Council has famously remarked, that the real problems of a litigant in the subcontinent arise when he's got a decree in his state. Execution is the problematic part. Now, so besides the courts and the speed with which courts decide these cases and the expeditious nature of the decision making, the important part will be the approach of the government. The government has, we cannot forget, been and will continue to be the largest litigant in the country. They have to decide that if they are going to appeal every matter all the way up to the Supreme Court, and they are going to breastfeed about every award that goes against it, and call it a conspiracy of the West, and a collusion of all the vested interests against the Islamic forces of the state of Europe, we will have a problem at that. We have to accept that international arbitration, whether we like it or not, is a fact of life. That it is what drives international commerce and drives international investment. And the government clogging the courts with frivolous claims is not going to help an expeditious conclusion of these matters. My experience for the time when I worked for the state was that in every single case that I advised that the government ought not to appeal to the Supreme Court, the government engaged a private counsel and appealed to the Supreme Court. The results were more or less, not always, but more or less what predicted, but it took a number of years. And that happened not because of any fault of the government, but basically lack of confidence in the officials who make the decision and a fear of the big brother throttling. So unless you invest your officers with the confidence to make quick and speedy decisions, this problem will remain. Unless we regard this as a collaborative enterprise to try to enforce the award rather than derail them, the problems will continue to persist. Speed will depend upon the approach of the judiciary, upon the approach of the government. I conclude by drawing inspiration from what my Lord Justice Sayyid Mansoor Ali Shah said before the while making his keynote speech at the Asma Jahangi conference. He concluded with a verse from Faiz, and that's very, very famous. मिट जाएगी मखलूक तो इंसाफ करोगे मुझसे फोटो अब हर्ष उठा के नहीं देगा. My lords, ladies and gentlemen, between the time of Faiz and today, things have changed considerably. Both the poets and the litigants have lowered their sights and trimmed their sails. I was looking at the recent quarterly produced by the Academy of Letters in Islamabad. I think it is volume number 135, which has a ghazal from Mr. Israr Ayub. इसका मतलब है मेरी अर्जी का अदालत पे असर हो कुछ तो, मेरी अर्जी का अदालत पे असर हो कुछ तो, फैसला कुछ भी हो, माय लॉर्ड मगर हो कुछ तो. सर बहुत शुक्रिया, आपने बहुत अच्छा एनलाइटन किया है और आपने जो लोगों ने स्टार्ट किया था. तो एक सर बातों से एक बात मैं जरूर सर ऐड करूंगा, जैसे आपने बताया कि लॉ जो ट्रीटीज थी तो अभी तक अमल नहीं हो पाया. तो सर एक इंटरेस्टिंग फैक्ट ये भी है कि पाकिस्तान इज वन ऑफ द अर्ली सिग्नेटरीज ऑफ मून ट्रीटी. इंटरनेशनल लॉ के बैठे हैं हमारे साथ यहाँ पे, तो अभी तक हम चांद पे नहीं जा सके. तो हमें उम्मीद करनी चाहिए कि हम चीज़ों को आगे लेके चलेंगे. दूसरा मैं वेलकम करता हूँ सीनियर जूनियर जज ऑफ द ऑनरेबल सुप्रीम ऑस्टिन हाई कोर्ट ऑनरेबल मिस्टर जस्टिस मोहम्मद शफी टू दिस ऑडियंस. And now there is a little change in the sequence of अभी नहीं, लेकिन I am not here. There is a little change in the sequence of the speakers because Honorable Mr. Honorable Minister of Finance has to go to attend a meeting, so he wanted to be on the stage at this moment. Therefore, before I invite him, I have to say a few words about Minister of Finance. No, I want to say something very important. So, sir, a BS and MBA from the Wharton School, University of Pennsylvania, an international banker, only Pakistani to be invited, exclusive membership of the Global CEO Council organized by WSJ Dow Jones Group, former chairman of the Pakistan Banks Association, chairman of Pakistan Business Council, and council member of the Institute of Bankers Pakistan. With us today is also this key personality who has to take care of the kitty of the government. Laws delays and procedural delays cause us to suffer the agony of delayed justice, a phenomena rightly not liked by many.
Judiciary is one of the pillars of the state, which is overburdened by millions of cases and under-resourced since long. The root causes of delayed justice have many dimensions, which include financial health of the judiciary to perform its constitutional function of administration of justice. It needs to be addressed. Apart from this, an authentic solution from experiences of the other countries who are performing well on the rule of law index is to consider alternative dispute resolution methods. Let us see how the Honorable Minister enlightens us about the new proposed legislation in this regard. I therefore request Mr. Mohammed Aurangzeb, Federal Minister of Finance, Senator Pakistan for his remarks. Welcome, sir.
Honorable Justice Cordially, Honorable Judges of the High Courts, Honorable Law Minister, Learned Attorney General, ladies and gentlemen, it's a real pleasure and thank you for the invitation this afternoon. My apologies for jumping with you here. Now we have often witnessed that large contracts, agreements, and transactions within Pakistan often opt for foreign arbitral tribunals due to the time-consuming mechanism prescribed under the Arbitration Act 1940. With the introduction of the Arbitration Act 2024, parties would be willing to not only transact in Pakistan, but also to resolve their disputes before the local arbitral tribunals and institutions. Now, this in itself, from my perspective, is a very positive indicator for the economic development and growth, inshallah, as we go forward. The Arbitration Act 2024, and I've been in the spring meetings, I've been in Saudi Arabia talking to the various investors there. I'm very clear that this will, inshallah, contribute to investor confidence. And as I mentioned, economic development in Pakistan by providing a modern, efficient, and enforceable framework for resolving commercial disputes. By promoting arbitration as a preferred method of dispute resolution and enhancing the enforceability of arbitral rewards, that creates a more stable and predictable business environment. But our investor, whether it's domestic or international, is asking for the same thing. It will encourage investment, foster business growth, and ultimately driving, as I mentioned, economic development in Pakistan. At this point, I must acknowledge the efforts of my Lord Justice Mansoor Ali Shah, whose years of labor has finally culminated in the drafting of the present law. Now, as we know, in all financial issues and disputes, speed is of the essence. And while it is heartening to notice that after the award has been announced, the challenge to the arbitration award hierarchy has been raised from learned civil judge to learned district judge. My only recommendation would be, sir, that at a certain financial threshold, the lawmakers and yourselves might want to think through whether below a certain threshold, the appellate element can be the learned district judge. But above a certain pecuniary financial threshold, maybe we should consider going straight to the Supreme Court. And matters which do not qualify under that threshold can continue to go to the district court. So I think that is something which I would suggest that may be considered as we go forward. The last thing I just want to mention is कि ये इतनी अच्छी development है because we're all looking for enabling environment in Pakistan for the foreign direct investment, which sort of we clearly need if we are to graduate from the various IMF programs as we see road to the market. तो इस चीज के लिए और इस enabling environment के लिए और इस legislation के लिए मेरी अटॉर्नी जनरल साहब से भी जो बात हुई है from Ministry of Finance, आपको हमारी तरफ से जिस किस्म की support की जरूरत होगी, इंशाल्लाह we will provide. With that, sir, Maktoum Ali Khan साहब को follow करना is not an easy act to follow. क्योंकि ना मुझे अशार आते हैं ना मुझे और चीजें जैसे आपने जिक्र किया. But I did want to leave this August forum, and my Lord, under your leadership, that we will inshallah be there to provide help, support, assistance, any way we can from the Ministry of Finance. Thank you, sir.
Thank you very much, Honorable Minister of Finance. Now we have with us Barrister Toby Lindau, King's Counsel and Arbitrator at Digital Hill Chambers, Singapore Group Practice. He is an arbitration lawyer in the world who has drafted the English arbitration law in 1996 and acted for various states in International Court of Justice, England and Singapore courts. He has joined us to Zoom to share his experience and comments on the draft bill. We are thankful to him for his time and energies to be with us in this technology. Over to Mr. Barrister Toby Lindau, King's Counsel. Yes, sir, please. Over to you, sir. Yes.
Honorable judges, ministers, ladies and gentlemen, Assalamu alaikum. I'm very, very sorry not to be able to be with you in person. I have been following the proceedings so far on the live stream. I'd like to put on record that Maktoum Saab has tested my Urdu to its absolute limit. Nonetheless, I congratulate all the speakers so far, and I'd like to start with sincere congratulations to all those involved in drafting this bill. Pakistan is one of the last jurisdictions around the world that still has the Arbitration Act 1940. That was an act that was a colonial hangover. It was distributed around the world and it led to many problems over the years. Most countries, virtually every country apart from Pakistan, has now moved on from that act. It's an act which has caused problems both domestically and internationally in terms of the conduct of international and domestic arbitration, and also in terms of the trust and faith of business people in the legal system. And after many previous attempts, it is a very happy moment, I think a landmark moment, to now see this arbitration bill 2024. It is, if I may say, a first-class draft. It is, I think, state-of-the-art in the sense that it draws on internationally accepted norms, as reflected in part in the Judicial model law, but it also draws on the experience that we have now almost 40 years on from the Judicial model law. It is a bespoke act, and it's crafted with a view to the particular issues in Pakistan that need to be addressed. I have no doubt that with the passing of the bill, Pakistan will be propelled into international ADR field and will command great respect. But I'd also like to sound a note of caution from the experience that we had in England with the passing of our 1996 Arbitration Act. We took the same approach that this arbitration bill takes, and that is not to cut and paste the Judicial model law, because England was a well-developed jurisdiction with respect to arbitration, with hundreds of years of case law and also experience. So it didn't make sense to graft onto that an Judicial model law which is skeletal by comparison. Rather, we crafted an act that addressed the local problems specifically. That is the same approach that has been taken with this arbitration bill. And it is an approach which, if I may say, I think is absolutely right. But the danger in changing the law in this way is that one has to stop old habits from creeping back in. If, as is the case in Pakistan and as it was in England, you have hundreds of years of case law to look at, partly English and partly local Pakistani common law, and you have many years of a particular mindset on the part of lawyers and the judiciary, then it is a challenge to sweep away all of the old assumptions and start afresh. And with the act such as this, that is really what is required, which is to actually change mindsets. And that is to stop lawyers from trying to bring in old principles pre-2024 Act, and to educate judges on the new approach to arbitration, both domestic and international. We had the same problem in the years after the 1996 Act was implemented, and it took a firm line on the part of our judiciary to make sure that lawyers were prevented from citing pre-1996 Act cases or pre-1996 Act principles. Well, one can see that there is that tendency in any event. In Pakistan law, one can still see attempts to cite Rupali and Hitachi, notwithstanding very clear statements on the part of the Pakistan judiciary that that is no longer good law. So the solution after this act, hopefully, inshallah, is passed, is widespread education of lawyers and also of judges. And what I would particularly commend is something that Professor Naqvi has mentioned is underway, and that is a clear explanatory report to accompany the bill. We did the same with our 1996 Act in what is called the DAC report, a report of the Departmental Advisory Committee that was responsible for drafting the Act. And it was a very detailed explanation of what was new in the law and what no longer applied from the old law. That DAC report in the 25 years since our Arbitration Act has been cited frequently. It's been incredibly important in changing mindsets and in bringing in a new era for arbitration. And I think that would be something critical to change the Pakistan arbitration environment. There are very useful clauses. One in particular, Pakistan has mentioned, clause 6, limiting the extent of judicial intervention. We have the same provision in section 1 of the 1996 Act in England, but it's taken some years for courts to really fully appreciate the meaning and impact of that provision. In this regard, I think Pakistan is blessed with a very strong judiciary that is pro-ADR, pro-mediation, pro-arbitration, and pro-enforcement. And the judgments that have been coming out even over recent months from Pakistan have already had a major impact internationally. I would like to mention, if I may, the landmark judgments already handed down by the Pakistan Supreme Court, in particular by the Honourable Mr. Justice Syed Mansur Ali Shah, and also from the judges of the Islamabad High Court and the Lahore High Court, including the Honourable Mr. Justice Jawad Hassan and the Honourable Mr. Justice Aurangzeb. These are judgments which already people in international circles are talking about. Pakistan is making its mark. It is turning a leaf. This is a very exciting new era, and I have no doubt that with the passing of this bill, Pakistan will cement its position. It will be, I think, the first of a number of steps that Pakistan has available to it to build what is now called an ADR ecosystem, including an international centre, perhaps domestic centres, mediation centres, and commercial courts, which all will help each other in a symbiotic relationship to ensure that Pakistan begins a new era in this field. The international arbitration and the business communities are full of hopes and expectations for Pakistan, and I wish you the best of luck, inshallah. Thank you very much.
Now for your enlightening us about the new law and how you see it, and also thank you for telling us a new way of interpretation of this law that to close the old and unacceptable regime and think with a refreshed mind and with a new way of thinking the same old thing. Thank you very Now let me introduce our next speaker, an LLM from Harvard and 37th Attorney General for Pakistan, Mr. Mansoor Usman Awan, who has a vast experience of practicing law in various countries. He is a member of the Law and Justice Commission of Pakistan and is also the Board of Members of the Federal Judicial Academy. I invite Mr. Mansoor Usman Awan, the Attorney General, for his valuable remarks. Sir.
All of that which is mentioned sounds like from another life. The life that I'm currently living is not very easy. But I'm very grateful to ALRC under the chairmanship of Justice Mansoor Ali Shah and with the able guidance of Mr. Rasool Ali Khan and with a great deal of effort put in by my friend, the most energetic Mr. President. I think the most significant contribution by Law and Justice Commission to this committee, and something which we need it today if we want to make any progress economic. There can't be any economic progress unless we provide certainty to businesses that they will have a robust dispute resolution system which will ensure fair and timely outcome of any dispute. तो उसके बगैर तो हो नहीं सकता, चल नहीं सकता. So ये एक extremely grateful. I, on behalf of the government, and the Law Minister is sitting here, he will also, I'm sure he will share these sentiments, and also on behalf of the legal fraternity as such. I think ये अब वो टाइम है कि अब हम आगे अब फॉरवर्ड लुकिंग अब वो वक्त है कि जब हम अब ये जो कमर्शियल डिस्प्यूट्स हैं इनको या अदर सिविल डिस्प्यूट्स अब उसको एक डिफरेंट लेंस से अब देखना शुरू करना. And I completely agree with Mr. Toby Landau's suggestion that once this law is enacted into an act of parliament, I think the Federal Judicial Academy can take the lead. We have to organize extensive workshops for training the lawyers and also introducing this law to the judges also. Because ultimately, when the matters will come before them, and they are the ones who are to apply this law, it will be great if we can give them this introduction to this law and what this law endeavors to achieve to the high courts and then also to the district judges. Very importantly, to the district judges. Now, one part of it, of course, deals with the commercial disputes. And I'm grateful to the Minister for Finance when I reached out to him asking for the necessary financial support in setting up the international commercial arbitration. He just didn't hesitate. He just said, whatever is required, we make the funds available. So I think now we are, this is May. I think barring the budget or other compulsions, budget session, we should look towards introduction of this law to the Parliament as an official bill on as soon as possible basis. I would request the Minister for Law and Justice to do whatever is necessary to make this happen. And also, I can see Advocate Punjab sitting here, and I believe representatives from the other provinces are also sitting, the government functionaries. I think simultaneously, I mean, either the provinces can resolve under Article 144 and empower the Parliament to legislate this for them on the domestic part of it, or alternatively, they can adopt the domestic part of this bill and into provincial laws. But whatever is possible for them, I think this should also be done simultaneously. In the end, I think we now have to ensure one thing, which is that once this law is enacted and the disputes come for arbitration, we now look towards arbitration through the lens of resolving the issue in the shortest possible time, not as a contentious litigant issue which we typically see happening in the courts. Because to be honest, I think the ordinary litigants are also kind of fed up of the delays in the justice system. And this is causing a lot of anxiety everywhere. So उस सबको खत्म करने के लिए and ये law जो है this can become a model for resolving the disputes, the commercial disputes locally, the other disputes where arbitration and contractual disputes where arbitration is the dispute resolution clause. And I think one day, I mean, the objective should be that every contract, local contract also carries this dispute resolution clause in the arbitration dispute or maker. So with this, once again, sir, thank you very much. This is Mansoor Ali Shah and the entire team. I couldn't have, I've gone through the law. This shows the amount of effort and energy put in by all of you. Thank you very much.
Thank you very much sir, for your comments and guidance to the academy. Hopefully, the academy will be preparing the modules for this law once it is enacted. Now, I invite my next speaker of the evening. The Lordship is a contributor to the jurisprudence in constitutional, commercial, arbitration, mediation, and banking by rendering landmark, benchmark, and bookmark judgments developing doctrines, tests, and principles. A lead to establish the commercial courts and overseas cell at the Lahore High Court. A frequent speaker at national and international forums, universities, and institutions. Appeared in various international arbitration in London, Singapore, and Dubai, and last year sat as a shadow judge in London Commercial Court. Authored leading judgments on foreign arbitration and mediation. Author of a number of books, articles, and research papers. A judicial educator by heart and an academic judge indeed. I mean Honorable Mr. Justice Jawad Hassan of the Honorable Lahore High Court, Lahore. So please come on the stage to share your lordship's views with all of us. Honorable Mr. Justice Jawad Hassan.
Honorable Justice Shah, the honorable judges, the senior lawyers who are sitting with us, who are senior advocates, like Mubin Khan Saab, there, and all other lawyers. It's a good day for Pakistan. But for the good day, I'll take 4 or 5 more minutes to explain why it's a good day. The good day is I'll give 2 minutes of my prelude and 5 minutes of my overture before I start what I want to say in 5 minutes. Is something very close to Pakistan is, as Mr. Cordially was saying, Judicial was saying, that the barometer of any economy in the world investment is the corporate law firm. They go to all investors, they ask the law firm, how good is your legal setup for investing in Pakistan? And the law firms put us in a very bad number 182 when we established the commercial court because there was no proper arbitration law. They have to be confident that our disputes are resolved in a timely way, and that parameter, the law firm, after today's settlement, inshallah, it will be a good innings that Pakistan is the beginning of bringing a new hybrid, technical, international kind of a law. Second reason was that we set up the commercial courts, we moved our ranking went up because we clarified certain issues with the commercial court, because commercial courts and the arbitration, ADR, arbitration, mediation, and foreign arbitration, they have a symbiotic relationship, as Cordially was saying. They have critical interdependence on each other. And while commenting on the law, we need to set up a commercial court. With Justice Shah and myself last week in the International Commercial Court Council Judges, where the entire world had commercial court, and we, inshallah, looking into the commercial court to set up this. To start my virtue now, Maktoum Saab 18 years ago brought Pakistan into an international fame by which we ratified the New York Convention in 1958 of foreign awards. Pakistan was lucky at that time to have the recognition and enforcement of Arbitral Award Ordinance in 2006, which was again and again, then finally we became an act, and the electoral act both was a beginning for Pakistan investment. That Pakistan, when are investing in the world, is a signatory to New York Convention, and are passing. While giving certain judgments, Shah Sahib clarified that what the court role is and what was a pro-enforcement bias in the TIC judgment, 2024 SCMR page 640, clarifying that Pakistan courts do not interfere in the foreign law, clarifying the pro-enforcement bias, giving the message to the world that what happened in the TIC judgment of the Lahore High Court has been set aside by the court by giving certain protection to Pakistan investment and the economy of Pakistan, which is right now in a critical stage. 18 years ago, a good news was by Shah Budulta, which we did. Today, after 40 years of United Nations electoral model law, Pakistan is thinking of bringing a new law. I will now start. The purpose was the first five angles as a technically as a judge, I'll flush it through a law. And first angle is legal anthropology of Pakistani arbitration law. The legal anthropology was 1940, India in decide in the Guru Nanak Foundation versus the Ratan Singh, 1981, Indian Supreme Court, page 644. The judges said we need to bring a new law for India to attract industry. And that was the report of Justice Desai in 1981, which led India bringing a law for all in 1976. It took us 84 years to think that we never thought of changing the law, which has been criticized by the Supreme Court, which has been criticized by our courts. And there were a lot of articles we never thought of bringing that law. What was now the second limb is the etiology of not having the law. What was the reason for bringing the law today? And that is, again, a story of numbers at the date I mentioned, 18 years ago, Udunsa, for 84 years after we are bringing this law. That is a story which starts from the journey of 2 years ago when me and Shah was in London, speaking to the entire legal community. Pakistan has various cases which are pending in London courts. Our awards are challenged. Our various awards are challenged in other countries. And while addressing the judges and the entire community, Shah said, the High Commissioner then is sitting with us here, Madhum Ali Khan Sahab. The High Commissioner himself spoke about Pakistan's stance on the ADR. And I made him sure that he should come and hear what Shah Sahab in London, in King's College and Gray's Inn, said, we have the law in arbitration. It's a high time. And then Justice Kumar Tablingal Sahab constituted a committee of the Arbitration Law Review Committee. The date was the 30th of April 2023. Just a month before was the judgment of the Supreme Court, changed the entire feet of the committee. And that judgment is not other than Justice Kushal Shah's 2023 SCMR 1011. That judgment is NHA versus Sanghu Construction, where, my lord, by looking at holding an arbitration forum of a party's of choice should not be lightly interfered by the court. And then at the end, the Lordship had to say that before party this order, we observed that the petitioner has dragged the award in the course for the last 10 years, which causes the vexatious litigation, wasting time of courts below as well as this court. Such trivial litigation clogs the pipeline of justice, causing delay in deciding genuine claims of the parties. And this kind of practice in ADR cannot be tolerated by the courts in Pakistan. We therefore put a pause to the party. We therefore erect and take action in the law. That was 13th February 2023. And then the 1st June, the committee sat first time with some Guru Shah, Sakan and Faisal Naqvi and all. And they started looking at the UN electoral model, whether to bring that law in Pakistan or not to bring that law in Pakistan. Can that law be workable in Pakistan? What is the jurisprudence of Pakistan? Can it be flushed out with the constitution? Can it not interfere on Article 4, Article 10A, Section 27, 28 of the Contract Act? Because that is a model law, and every country are divided in the world a common law or a civil law. And that is the approach to see. What they did was, in that
particular law. In that time, by looking at we now third is I talked about legal anthropology. I talked about etiology for why the law came, because the law had to come, because this law, this judgment of some construction brought the government to make the law. What happened was, unfortunately, 84 years Pakistan history. Only guess how many judgments have been passed under the 1940 Act. Any one person can guess why the law has not been developed, why the jurisprudence was not developed. Can anybody guess 84 years of Pakistan and how many judgments in law site or anywhere in the anti-40 Act? That's a bad news. Only 46. 1952, clearly Supreme Court 52, and then last referendum of Justice Shah is the ICPS 2024 SCMR 640. Only 46 judgments. Law could not have been developed. There was no legal anthology of the law, or jurisprudence for a law, for lawyers to say why was the need. The need is, when you look at the anthology, the need is what Facility and the committee has brought into the preamble of the law. The need is only 5 basic principles, global principles. The need is when this is Bashir Alam in the Orient Power case mentioned that Pakistan is a party. Pakistan has signed the Model Convention. We in a global village, 2021 SCMR page 1728 in paragraph 26. He held that Pakistan, we are in a global village and we have a fast-paced vibe. Let's have a law. Again, Supreme Court examined 5 areas and reason that the no judgment came is party autonomy. The first preamble, the preamble of this draft bill talks about party autonomy. Never before that. Courts have mentioned. Second is less intervention by the court. In the previous law, there were 5 stages. The Shah Sahib had to write that 10 years it took. In some cases, like Producer was mentioning how much time it's taken. Some study says 1,700 days are taken in arbitration. It should not be. Third is because there is intervention by the court. And third and most important, it would be that the principles are the reduction of intervention and also the basic purpose of the law would be to talk about the speedy results. So, looking at the law, examining the 46 judgments and what they all say, all are saying the same thing. No intervention, less intervention. Then mostly they are saying that we look at the unitary model law, it's high time that we should do this. And then mostly saying, mostly on the delay. Why was doing it? I was very happy to see the law and that section 8 and 9 talks about an agreement. Last year, 3 years ago, a case came to me in my court, and I was looking at the research, couldn't find anything. I said, there's nothing in Pakistan you can find. Was whether an arbitrator can be appointed orally. I mean, can there be an oral agreement for arbitration? The answer is no. Section 2 of the previous law, but this is a very good section, that's written section 8 and 9. I, in that 2020 PhD 2021 Lahore C98, had to write a lot from Indian jurisprudence that arbitration has to be expressed in writing of the parties. There has the intention of the parties, which is arbitrable. And then you cannot ask the court in the court that I am appointing you as an arbitrator. You cannot do that if there is nothing in writing. That principle which I was trying to do, that has been very well covered by you in section 8. And then I'm looking at what other sections will require. I will criticize also at the end, but not yet. So then we'll have to see the issue of you cannot mix the foreign award with this law. It's because that was Justice Shah in the IC 2020 SCMR has clarified, which I clarified in the scheduled judgment PLD 2021, Lahore 623, that code is C, is a capital C. And Doomsa was writing the law, but we are the 2D is the section, and the code means a court is a high court, which is notified by a chief justice or a judge. If any intervention of the foreign awards is made by a civil court, again a history of the TIC will start again in Pakistan. TIC started in 2014, a judgment by Lahore, 2012 by Lahore High Court of an award taken by the Singapore International Arbitration. You cannot afford to bring out anything which is that's why you have expressly barred the jurisdiction of any foreign award. Because foreign awards can be of the LCIA, SIAC, or DIFC, any of the award, because if we try to mix that now, this will again will go and violate the law laid down by the Supreme Court of Pakistan. Supreme Court has now given in the doctrines that how courts in Pakistan examine the provisions of the law. And we have to clarify 2C and 2D, which have capital C and a small c. In my federal judgment, I had to clarify by typing that a C means capital C. The Muslims have wrote in section 3 and 4 of the law. You can't say 2C, C means a small c. That issue is okay, went to a Peshawar High Court of a power company. Some cases are pending there, in some courts here, in Islamabad also. One case is pending in my court. What is the C in the court means? Higher court or civil? So this is something, and then the issue of the, lastly, to say good things, we look at the anatomy of the law. We are talking about legal ecology, ecology, ecology. Now we have to examine the anatomy of the law. Law has 11 chapters, 54 sections, and it clarifies a lot of issues which is not clarified in the other law. Looking at the section with the Pakistani constitution, looking at the chart, when I'm making a chart of the law, see what is there I can see which violates Article 175 with Article 10A and Article 4. One is against a public policy. You cannot stop a person to file a case. Section 28 of the Contract Act 1872. It will be looked into by the courts once the law is passed. If the law is getting its two would be
Parliament has its own brain, inshallah.
yeah, and thus is and what I really like is that while saying good things, what people say now the trend has changed. Say no to litigation, say no to arbitration, and say yes to mediation. The approach which we started now, followed by Lahore High Court, Saab Yusuf Saeed in Karachi, Yusuf in Karachi, Shah followed immediately in 2022 SCMA, 2024 SCMA, is something very, very important. Is if Faisal, you have given a very good opening in section 33, which says now when you see the global judges, they say sometimes a matter went to a court, then to an arbitrator, and from an arbitrator it went to a mediation for a settlement. So there's no bar of settling a dispute. While we were in Singapore, me and Hassan were there in Singapore, remember George said to us, the case was pending in the UK, the US courts, went to the arbitration, came to him and decided as a mediation. You have given that line in section 33, where you instead stated that the arbitral tribunal to encourage settlement of disputes with the agreement of the parties, arbitral tribunal may use mediation, conciliation, and other procedures at times. This is something, a beginning. If you ask me which is the best section of the law you like so far, I say under section 33. Parties don't want to invest now. Doomsa knows it's a huge cost of a party involving international arbitration, billions of pounds. And when I was sitting in a judge in London and enjoyed it, only thing I remember was coming out from different courts, and that the English judge said, just a husband, think what the cost of this case could be. £3 million each is a case of, it's only a cost of a case. QCs, King's Councils, top law firms. As Tommy Lando very well said, that we are in a global village, and Pakistan is the last country with the last 1940 Act. But we are not a last country. We are a country passing the law, inshallah, in the 40th anniversary of the electoral model law 1940. Thank you.
Thank you very much for a wonderful analysis of the upcoming law. And yes, the word used by the Honorable Minister, the brain of the Parliament. So we will be waiting for that brain, how it is being used in passing this law. Okay. Now, sir, we have our next speaker, who is an LLB honor from Wales on a scholarship, a barrister of Lincoln's Inn, and an LLM from SOAS University of London. His Lordship has also the honor to represent Pakistan in international arbitrations. There are a number of judgments where His Lordship has deliberated on arbitration law jurisprudence. Judicial education as a support to law reform is close to His Lordship's heart. I invite Honorable Mr. Justice Mehbul Hassan Aurangzeb, Judge Islamabad High Court, for his honor's remarks on the arbitration bill. Honorable Mr. Justice Mehbul Hassan Aurangzeb.
Assalamu alaikum, ladies and gentlemen. Thank you very much, Mohan, for that introduction. Arbitration bill, much awaited, if enacted, will bring about a great transformation. Rather, it will be revolutionary in the law of arbitration. Many a concept, as also a mass of case laws, will become obsolete. The immediate need is to get introduced to this new law and to gain familiarity with it. The legal mind is apt to think in terms of the Arbitration Act 1940 because it's remained in force for 84 years and it is still in force today. This law will continue to apply to arbitration proceedings commenced before the new law is enacted. The rules and notifications made under the 1940 Act are also protected as long as they are not repugnant to the provisions of the new law. However, the rules made by the High Courts under Section 44 of the 1940 Act may require a fresh law to make them compatible with the new law, if I may call the bill the new law. It cannot be said that the case law on the new law does not exist, as advantage can be taken from the judgments rendered in the countries that have interpreted the provisions of law which are in parallel to the provisions of the new law, especially India, where the Arbitration and Conciliation Act was enacted on the 22nd of August 1996. It was preceded by key ordinances before it was enacted. I had the opportunity to confer with the Law Secretary a few moments ago to ask whether the provinces have passed resolutions so as to enable the Parliament to pass this law, so that it is applicable in the entire country. He told me not as yet. But I urge the government that as far as the Islamabad Capital Territory is concerned, for which the legislature is the Parliament, should lose no time in at least enacting it for the Islamabad Capital Territory. The provinces then, through resolutions, can adopt it. The Indian Conciliation Act, Arbitration and Conciliation Act, was preceded, as I said, by 3 ordinances. The recognition and enforcement of the foreign arbitral awards was preceded by 8 ordinances. I'm not in favor of reformulation every now and then, but I believe that this new law is the need of the hour, and we should not lose any time in enforcing it, at least in the capital. A fleeting glance at the new law shows that it is mainly based on the model law on international commercial arbitration, adopted in 1985 by the United Nations Commission on International Trade Law. The General Assembly of the United Nations had stressed the desirability of uniformity of the law of arbitration and conciliation procedure. The new law has thankfully done away with arbitration with the intervention of the court. there is no provision akin to Section 20 of the Arbitration Act in this law. And as the legal practitioners know well, that was the section of the 1940 Act that was most used in the courts. And to use the words of Justice Desai in the case of Guru Nanak Foundation, which was referred to by Justice Jawad Hassan, the provisions of the 1940 Act did indeed make the lawyers laugh and the legal philosophers weep. We, while in the practice of law, laughed when we obtained injunctive orders to stay international arbitration. I'm sure it made the legal philosophers weep. The 1935, Section 35 of the 1940 Act provides, in effect, that if arbitration proceedings were commenced with respect to the subject matter of a reference within the parties to the reference, and the arbitrators had been given notice of such legal proceedings, all further proceedings before the arbitrator would be invalid. This provision has also been thankfully done away with. On the contrary, Section 9(6) of the new law provides for arbitration to be commenced or continued, even if legal proceedings are brought or are pending before a court or a judicial authority. In other words, the initiation or continuation of arbitration proceedings has not been conditioned by an order for a stay of the legal proceedings. Under the new law, arbitration can continue even where the arbitral tribunal gets notice of the judicial proceedings. It appears that nothing short of an injunction restraining the arbitral tribunal from proceeding further would suffice in such a situation. The court is no longer left with the discretion to stay arbitration proceedings, as it did under Section 34 of the 1940 Act. Once the court is convinced that the parties before it are parties to an arbitration agreement and the dispute that they have raised is covered by the arbitration clause in this agreement, he has to mandatorily stay the proceedings, or to the extent that they are covered by the arbitration clause. A very significant feature of the new law is that intervention of the court in arbitral proceedings has been minimized. There were numerous provisions in the 1940 Act which provided for court intervention at almost every stage of the conduct of the arbitration proceeding. The new law, I believe, provides only 2 occasions when court intervention can be sought at pre-arbitral stage of the proceeding. The grant of interim measures by the court under Section 10 of the new law, and where there is a controversy regarding termination of the arbitrator's mandate, a party can apply to the court to decide the matter under Section 16(2). There is no provision in the new law like the one in Section 5 of the 1940 Act, where leave of the court was required to revoke the authority of an appointed arbitrator, and Section 15, where the power of the court to modify the award was there. The power of the court to remit the award for reconsideration under Section 16 of the 1940 Act is also not there in the new law, I believe. Section 41 of the new law confers on the arbitral tribunal the status of a decree. What a welcome change. In that, it is to be enforced in the same manner as it were a decree of the court. A party need not go to the court to make an arbitral award in lieu of court and get a decree drawn in terms of the award, which was necessary, mandatory under Section 30 of the Arbitration Act. Once the objections were dismissed, Section 17 provided that a decree would follow. The arbitral award can now be enforced directly through execution proceedings, thus saving time. A combined reading of Section 6 and 39 of the new law leads to the conclusion that courts have now no inherent powers to set aside an arbitral award unless there is an application by a party made for this purpose. The controversy which has existed under the 1940 Act, whether courts have suo motu power to set aside an award, does not survive. With regard to the grounds for setting aside an award as contained in section 39(2) of the new law, it must be said that they are more precise, specific, and articulate than the ones contained in section 30 of the 1940 Act, which use sweeping expressions like the arbitrator having misconducted himself or misconducted the proceedings. A new provision has been made in the new law empowering an arbitral tribunal to give an interpretation of specific point or a part of the award upon the request of a party, which can be made only if it was so agreed by the parties. This is section 28(1)(b). The arbitral tribunal has also been empowered to make an additional award, something absolutely new, regarding the claims presented in the arbitration proceedings but omitted from the arbitration award. This is section 28(4). I also see that Mr. Hassan Naqvi and Mr. Samiuddin have taken into consideration areas that were not addressed and catered for by the Indian Arbitration and Conciliation Act of 1996. This caused many disputes. And for instance, there was no explanation of the word public policy, which is made a ground for an award to be set aside. The law was amended in India in 2016, giving an explanation of what constitutes public policy as a ground to set aside an award. This explanation is now contained in section 39(3) of our new law. Since I was asked to constrain myself to 5 minutes, I hope I have done so, but I congratulate the drafters of this bill on framing such a beautiful piece of proposed legislation, and I urge the government to lose no time in enacting. Thank you.
Thank you, Your Lordship. Now I invite Honorable Senator Mr. Alam Ali Tarar, Federal Minister for Law and Justice, Government of Pakistan. He is also Vice Chairman of the Board of Governors of the Federal Judicial Academy. Senator Mr. Alam Ali Tarar. Presenting to the stage.
बहुत शुक्रिया जी। मेरे पास भी सर दो ड्राफ्ट हैं टॉकिंग पॉइंट्स के, वन रिटन बाय सेक्रेटरी लॉ एंड जस्टिस राजा नईम साहब और दूसरे बड़ी एबल सीनियर एडवाइजर हैं डॉक्टर आयशा रसूल। यही थे, फिर मैंने सोचा कि आज के मेज़बान डीजी शाह साहब, उन्होंने कहा कि आज के इस ऐवान में बड़े मुअज़्ज़ज़ और काबिल लोगों ने बात कर दी है, तो मैंने, क्योंकि आज रिसीविंग एंड पे, मैंने कहा मैं काबिलियत की बातें आप पे छोड़ो, मौज़ूदों में मैं रह जाता हूँ थोड़ी बात करके। आपके जो जस्टिस मंसूर शाह साहब ने इस पे बात करनी है, अपना टाइम देने दूँ। मौजूद साहबान, बिलखुसूस जो मुसन्निफीन हैं, ड्राफ्टर्स तैसर और समी साहब, मखदूम साहब की सरपरस्ती हमें आप सबको हासिल रहे। एक खजाना है हम सबके लिए उनका हुनर का भी। बड़े माशाल्लाह ब्राइट फेसेस हैं यहाँ पे। बहुत शुक्रिया जी लॉ एंड जस्टिस कमीशन का, जिन्होंने ये एफर्ट की, आप सब ने मिल के, और फेडरेशन फैमिली ने आज इसे होस्ट किया। ये बुनियादी जिम्मेदारी हमारी है पार्लियामेंट की। आपने उसमें अपना वो जो रोल है लॉ एंड जस्टिस कमीशन का, कि आप बड़ी अच्छी सिफारिशात देते हैं हमेशा, और अभी अभी जस्टिस मियां सर ने कहा कि वक्त ज़ाया नहीं करना चाहिए, और दूसरी राय ये है कि कानून साजी में वक्त लेना चाहिए और बहुत ज़्यादा वक्त लेना चाहिए। लेकिन मैं समझता हूँ कि इस ड्राफ्ट को तैयार करने वाले लोग इतने संजीदा और इतने तजर्बाकार हैं, और फिर इसमें वो जो लोक पलट दुरुस्त करने वाले जस्टिस जवाद हसन जैसे एसेट जो है, सरमाया हमारे दरमियान मौजूद है। और हमें ये भी यकीन है कि अगर ये ड्राफ्ट जस्टिस मंसूर शाह साहब के नज़रों से गुजरा हुआ है, तो यकीनन یہ اس معیار پہ پورا اترتا ہے جو کہ اس ملک کو درکار ہے آج کے لیے. تو اس یقین دہانی کے ساتھ کہ وقت ضائع نہیں کریں گے اور انشاءاللہ العزیز سر آج ہمیں یہ موقع مل رہا ہے کہ ہم یہ وصول کریں گے ڈرافٹ آپ سے, اور میں پوری ذمہ داری کے ساتھ جیسے میرے فیلو کلیگز نے بھی کہا, اٹارنی جنرل نے اور وزیر خزانہ نے, اور یہاں پہ میں ایک بات ضرور کہنا چاہوں گا کہ حکومت پاکستان کی دلچسپی اس بات سے ہے یہاں ہے کہ وہ تمام ریلیونٹ لوگ جنہیں آج جہاں پہ ہونا چاہیے تھا وہ موجود تھے, اور وہ اپنے اس عزم کا اظہار کر کے گئے کہ اس کام میں کسی قسم کی غفلت نہیں ہوگی, تاخیر نہیں ہوگی. میں تو خیر ود دا پیسج آف ٹائم کچھ سرکلز میں ویسے ہی مجھے تیز قانون سازی کے حوالے سے کافی میں میرے احترام اور میرے تنقید رہا ہوں. میں سمجھتا ہوں سر جب قانون کا ڈرافٹ محنت کر کے تیار کیا گیا ہو اور پارلیمنٹ نے اسے ایک دفعہ دیکھ لیا ہو تو پھر غیر ضروری تاخیر بھی سر بڑی تکلیف دہ ہوتی ہے. ہم نے پچھلے ہی دنوں پارلیمنٹ نے پہلا قانون پاس کیا, میں 1-2 منٹ لوں گا, جو ہم نے جو ٹیکس لیٹیگیشن کی جو رجیم تھی سر اس میں بڑی فنڈامنٹل چینجز کی ہیں. تو 8 روز کے بعد جب دوبارہ نیشنل اسمبلی میں وہ ٹیک اپ ہوا تو ہمارے دوستوں نے کہا کہ نہیں ہم نے تو ابھی اسے دیکھے ہی نہیں. تو میں نے کہا بھائی 8 دن 7 میں نہیں دیکھا, اگلے 8 مہینے بھی نہیں دیکھیں گے. آپ کے سامنے رہا یہ ڈرافٹ, پھر اس پہ ڈیبیٹ ہوئی, باتیں کھلی اور پارلیمنٹ نے اسے خوشدلی سے پاس کر دیا. تو اجرت ضرور ہونی چاہیے لیکن وہ تحمل کا بھی تھوڑا عمل دخل ہے. کئی چیزیں سر اچھی نکل آتی ہیں جب ہم بیٹھ کے, میں آئی ہیو ڈن سو مینی تھنگز ان 3 years. میں جب آیا 21 میں سینٹ میں تو I was blessed to have members of the committee جو ہماری لا اینڈ جسٹس کی اسٹینڈنگ کمیٹی ہے, فاروق نائک صاحب, سینیٹر علی ظفر صاحب, رضا ربانی صاحب ہمارے سینئرس ہیں, ان کے ساتھ بیٹھ کے کام کیا اور باقی بڑی باریکی سے کلوز ٹو کلوز, کلوز بائی کلوز, اور ایک ایک چیز دیکھ کے آگے چلتے. سنس کمیٹیز آر ایکسٹینڈیڈ آرم آف دا پارلیمنٹ تو بڑی آسانی سے ہو جاتی, اسی لیے شاید ہمیں فلور آف دا ہاؤس پہ کم ڈیبیٹس ملتی ہیں. پیپل ڈو بلیو کہ یہ ٹیکنوکریٹس ہیں, یہ چیزوں کو زیادہ بہتر دیکھ سکتے ہیں اور کر سکتے ہیں. تو اس میں بھی سر بالکل پورا آنے سے پہلے وزیر اعظم پاکستان سے بھی میں نے کہا کہ یہ اس طرح کی ترکیب ہے اور یہ معاملہ ہے. ہی واز ایکسائٹیڈ ایکچولی, اور وہ خود چاہتے ہیں. یہ بات میں نے اس لیے کی ہے کہ سر یہ ساری وجہ سے عدالتی نظام, حکومتی نظام, دفاعی نظام, یہ سب کچھ جڑا ہوا ہے پاکستان کی معیشت سے. سر ہم ایک صحت مند معیشت ہیں تو یہ سارے سلسلے چلتے رہیں گے. میرے منہ میں خاک جس نہج پہ ہم پہنچ چکے ہیں, اور اگر آج بھی ہم نے معیشت کو سہارا نہ دیا تو شاید یہ دوبارہ یہ ٹی وی پہ چلتا ہے کہ یہ موقع دوبارہ نہیں ملے گا, شاید صورتحال ایسی ہے. اور یہ وہ قدم ہے سر جو ہمیں فارن انویسٹرز کو کانفیڈنس دینے کے لیے اور اپنے کاروباری طبقے کو جنہوں نے اس گاڑی کو دھکیلا ہوا ہے, جو چلا رہے ہیں سر, یہ جو ٹیکس پیئرس ہیں جن کی وجہ سے ہم سارے یہاں پہ کام کرتے ہیں, یہ تبھی ممکن ہے کہ ہم ان کے اعتماد میں اضافہ کریں. اور اعتماد میں اضافہ ظاہر ہے سر وہ کسی پٹی چیزوں سے تقریروں سے نہیں ہوتا. علامہ نے بڑا خوبصورت مخلوق صاحب, میں تو اسے ایک سبق کے طور پہ یاد رکھتا ہوں کہ جہان تازہ کی افکار تازہ سے جنم کہ سنگ و خش سے ہوتے نہیں جہاں پیدا. اور دوسرے انہوں نے کہا کہ جو تھا نہیں ہے تو ہے نہ ہوگا, یہی ہے گردش زمانہ. پرانی چیزوں سے چپکے رہنے سے بھی معاملات نہیں چلتے. جب تک آپ اسے موجودہ وقت کے تقاضوں سے ہم آہنگ چیزوں کو کریں گے سر, ہم آگے نہیں چل سکیں گے. اور یہ بڑی خوبصورت ایفرٹ ہے. ہم نے اپنے آپ کو اس پیس پہ چلانا ہے جس پیس پہ باقی دنیا چل رہی ہے. مجھے انٹرنیشنل سینٹر کے قیام کے لیے کہا گیا سر, ایک دو چھوٹی چھوٹی چیزیں. ایک تو گورنمنٹ ہیز پرنسپلی ڈیسائیڈڈ اینڈ وی ہیو ٹیکن سو مینی اسٹیپس. ایک آدھ چیز ہے بھی ہے, سنگاپور کنونشن کے سگنیٹری بننے جا رہا ہے پاکستان میں انشاءاللہ, جو بھی کئی حوالوں سے بہتر ہوگا. دوسرا تھینک یو ویری مچ جی فیڈرل جوڈیشل اکیڈمی کے بورڈ نے, میں بھی اس کا حصہ ہوں, مہربانی کی ہے हमें जगह की तलाश थी कि इस निज़ाम के लिए सेंटर कहाँ पे कायम किया जाए। तो थैंक्स टू जस्टिस मंसूर अली शाह, उनकी भी रफ्तार बड़ी अच्छी होती है चीज़ों की। हम डिस्कस करके आए तो विद इन 24 आवर्स वी रिसीव द लेटर कि आप जो फेडरल जुडिशल अकेडमी का साबका या मुख्तसर ये मुल्का कैंपस है, बिल्डिंग है, उसमें हम वो कायम कर सकते हैं। आई ओरली एक्चुअली गॉट नॉट फ्रॉम माय प्राइम मिनिस्टर, और अब हम इसके पीसी बन पे और उन सारी चीज़ों पे इंशाल्लाह वो काम शुरू कर देंगे। आप मुसद्दक़ा आज हमें मिलता है, रेस्ट एश्योर, जैसे मंसूर अवान साहब ने कहा है कि बजट वाले वो थोड़े से दिन आते हैं। ये बात आप सबके इल्म में है कि आईसीटी के लिए जो कौमी असम्बली का सेनेट है वो फौरी तौर पर कर सकते हैं, लेकिन आर्टिकल 144 के होते हुए प्रोविंसेस में से अडॉप्ट करेंगे। वेरी एबल एंड पॉपुलर एंड पंजाब जो कि काफ़ी सारा बड़ा इलाका है पाकिस्तान का, डायरेक्टर जनरल साहब की सुना जी आजकल मैंने इनकी राय को बहुत अहमियत दे रही है पंजाब असेंबली, पार्ट भी हैं आप उसके, तो आप अपना रोल प्ले करेंगे। बाकी प्रोविंसेस से आई हैव ऑलरेडी टेकन अप सर, मेरा ख्याल है ये चीज़ें बहुत बेहतर हो जाएगी जी। आप सबका बहुत मशहूर हूँ जी, बहुत शुक्रिया इस वादे और अज़म के साथ कि हम सब ने मिल के सर इस गाड़ी को आगे चलाना है, और एक खुशहाल पाकिस्तान की बुनियाद के लिए एक मजबूत निज़ाम जो है वो ज़रूरी है, और ये भी उसी में सर एक बड़ी मजबूत बुनियाद होगी। बहुत शुक्रिया।
Thank you very much, Honorable Minister for Law. Before I invite Honorable the Chief Guest, I would like to comment on a constitutional perspective of arbitration law in Pakistan. Justice Dr. Munir Ahmed, my late father, in one of his research papers had highlighted the concept of constitutional arbitrator. This paper is available online. I will read its opening paragraph. In this paper, I have made an attempt to bring forward the concept of constitutional arbitrator from the provisions of the Constitution of Pakistan 1973. How this arbitrator is different from an ordinary arbitrator appointed under the Arbitration Act is an important question for constitutional debate. Likewise, we need to find out dynamics of constitutional arbitration. I have left the field open for further debate, analysis, and research. Let me tell this august audience that the constitutional arbitrators are to be appointed by the Honorable Chief Justice of Pakistan for certain disputes mentioned in 1973 Constitution. The dynamics of constitutional arbitration thus need deliberation. I am not sure if the new proposed arbitration bill has attended to the constitutional requirements to deal with some jurisprudential questions of law and procedure, if any such arbitrator is appointed by the Honorable Chief Justice of Pakistan. The paper just mentioned above has provided 10 questions at its end, which the Law Commission may look into. Let me read them for the audience. What may be the qualification of a constitutional arbitrator? What law applies for proceedings of a constitutional arbitrator? Whether an award made by a constitutional arbitrator is challengeable before a civil court? How and under what procedure a constitutional arbitrator can be removed? Who will initiate the name of a person to be appointed by the Chief Justice of Pakistan for such a slot? Whether any such award is amenable to the writ jurisdiction of the High Courts? Whether the Arbitration Act 1940, now there will be a new law and that's why I am reading it, whether the new law caters for these questions will apply on such an arbitrator, whether the order to appoint an arbitrator by the Chief Justice of Pakistan can be challenged before a court of law, a High Court or Supreme Court itself under their writ or original jurisdiction. I hope that all concerned will look into all and to see if the new law will provide an ample answer to these questions. Now I would like to take privilege to request Honorable Chief Guest to come on the stage and deliver his Lordship's concluding remarks, being the chairperson of the Arbitration Law Review Committee. Honorable Mr. Justice Salim Mansoor Ali Shah, Deputy Minister of Pakistan.
So, yes,
Assalamu alaikum. Let me just begin by a quote because I personally draw inspiration in this entire ADR world of ours from this saying of the Holy Prophet, peace be upon him, who told us that achieving reconciliation between people is better than observing voluntary fasts, offering voluntary prayers, and offering voluntary charity. So it's a big thing to reconciliate and settle matters between us. That's the kind of driving force behind all this. Let me clarify because the law minister said that the law is passed through my eyes. I've seen this, and this should be the best law there is. And no, let me just clarify that I stand here as a member of the Law and Justice Commission, not as a judge of the Supreme Court. I wear a different hat when we look at this law. I don't wear the hat of a judge of the Supreme Court, so if the law comes before us, it's challenged, it will be examined differently. So let me clear that because this is not being presented to the government by the Supreme Court of Pakistan. This is by the Law and Justice Commission of Pakistan, which is a statutory body established under the Law and Justice Commission of Pakistan Ordinance 1979, and its preamble talks about a systematic development and reform of the laws, which is a mandate. And Section 6 of this law in particular provides that they can make laws in accordance with the changing needs of society, and we can give recommendations to the government regarding law reforms. And it is in that vein that this effort has been done. The committee was constituted, which we call the Arbitration Law Review Committee, somewhere in April 2023, and I must compliment and acknowledge that the former Chief Justice, Justice Umar Ata Bandial, was very kind in constituting this body. Had he not done that, we would not have been here today. So I must thank him for this, that he accepted this. We made a request and he acceded to it, and he set up this committee. And I also thank the current Chief Justice, Mr. Lisa, for allowing it to continue, and he gave us the blessing that we must complete this work that we started. So the need actually, let me just underline what was the real need for this and why did we think of revisiting arbitration at 1940? For us, it's the domestic arbitration as well as the international arbitration, both are important. There is no doubt that the underlying feature is the businesses and the commerce behind it, but it applies to both the domestic as well as the international arbitration. So the pendency in our country, which I've mentioned several times in various forums, we have 2.4 million cases and they're not really moving. They're there. And we're talking about 5 high courts, we talk about district judiciary, we talk about ex-cater courts, a total of about 2.4 million cases that are not really moving. So the pendency largely, about 85% of it is in the district courts. And we think that by setting up, which I'll speak later, about ADR centers and the new arbitration law would ease things in domestic arbitration, amazingly. See, the way things will change with this new law in domestic arbitration would actually be addressing this backlog and this pendency, which needs to be addressed. It's been high time that we do that now. We must also acknowledge that and understand that about 70,000 cases are being filed every day in the district judiciary in Pakistan. 70,000 cases are being filed every day, and about 4,000 cases are being filed per month. 70,000 cases are being filed per month in the district judiciary, and 4,000 cases per month are being added to the high courts. So we need to understand what's the need for having alternate avenues available to us in the shape of arbitration or mediation. Let me also flag that 1.6 million cases were decided last year in the year 2023. Still, the pendency remains at 2.4 million. So you can just imagine that there's a lot of work coming to courts. A lot of people are approaching courts as a litigious society. Number of cases are coming in. We need to find avenues to address this because we're in the business of dispute settlement. So this dispute settlement mechanism needs to have avenues. We just started work on the arbitration, as you see, on mediation and ADR centers. And at the same time, we're trying to work on technology to address matters which are going to be addressed by courts and trying to bring in AI and information technology going down to courts to figure out how district judiciary ought to refashion itself and to address these challenges. So you've already heard from, so I just want to really sort of take you through the process which is very important. What did we do when the committee was constituted? How did we go about it? Because the transparency of the process is important. So the committee, we sat down, we met in April last year, and I must thank Barrister Mahmood Ali Khan, who was the lead in this committee. Then we have Mr. Faisal Lakwi, Mr. Samuel Dean, and Faisal Khokhar, one of our ablest senior civil judges that we have at the Supreme Court Research Center, was part of this process. So number of deliberations took place, number of meetings took place, and it was in our discussions that we decided to carry this forward and put out a public draft eventually, which went out to the website, and it was open to the public to comment. But more importantly, Mr. Faisal Lakwi, who was the force behind it, actually after the first meeting came up with the first draft in a couple of months, and I think that deserves a big clap because on 17th of August, he came up with the first draft, which we thought was amazing because he took the charge and he said, I'll do it. And he came up with that with the assistance of Samuel Dean and under the supervision of Barrister Mahmood Ali Khan, which was amazing. And I think the real work has been done by them. I'm just a ceremonial head here of this committee. The real exercise has been done by Faisal Lakwi and Samuel Dean with the assistance of Zafar Khokhar and under the supervision of Barrister Mahmood Ali Khan. So I think a big compliment goes to them for doing this exercise in this limited time frame that they had. So once we sat over several meetings, that the draft came before us, we looked at it, we deliberated, and there was a second draft, and then the draft was put out, as I said, out in the public on the website for people to comment. And then also the matter was, the draft was shared with a lot of prominent law firms, at the High Court Bar Councils, Chambers of Industry, domestic arbitral institutions, and international arbitral institutions like LCIA, ICC, and the Permanent Court of Arbitration. In total, the draft was sent to about 100 stakeholders to review and look at it. Online discussions were held by Mr. Faisal Lakwi with various international institutions and centers in relation to issues of international institutional arbitration. So it was ICC, it was Delhi International Arbitration Center, it was the Permanent Court of Arbitration, it was the Dubai International Arbitration Center, the Saudi Center for Commercial Arbitration, International Arbitration and Mediation Center, Hyderabad, BVB International Arbitration Center, Asian International Arbitration Center, International Advisory and Dispute Resolution Unit, Hong Kong International Arbitration Center, Korean Commercial Arbitration Board, in London, the Court of International Arbitration, and all these discussions were made possible by David Grief and Toby Landau, who we just heard. The ALRC is grateful for their assistance. So this draft went around all over the world, and people looked at it and made their comments. So one would not be wrong in saying that perhaps it was one of the most, state-of-the-art laws coming out on arbitration in the world. I think it deserves a big clap to say thank you. So, having said that, what is important now is how do we go forward, you see. We've seen the salient features, we talked about it, Mr. Faisal Lakwi talked about it, Mr. Mahmood talked about it. I just sum it up in 4 points, which I think are important. It's the reduction of judicial intervention in arbitral proceedings. That's one main big thing. Because earlier, in the first round, under 1940, you would go doing arbitration, and then you'd probably end up the rest of your life in the courts dealing with that arbitration. So nobody really went for arbitration because it's like doubling the exercise. You go for arbitration and end up in court. So the reduction of judicial intervention, I think, is the big salient paradigm shift. The speedy resolution of disputes timelines for different stages of arbitral proceedings is again a welcome addition to this. Then the recognition of the principle of party autonomy is brought in and caters for institutional arbitration. Now, on the issue of institutional arbitration, I'll be requesting the law minister here to please consider that we go ahead and set up the first international commercial arbitration center in Pakistan. This is much needed and it's been waiting for such a long time. I've been informed by the former Attorney General that about $7 million was spent as costs in taking matters out to London or to other places for arbitration because we didn't have a facility of our own. So it's high time that we set up that center in Pakistan, and that would energize the entire sector. A lot of private sector players will come in to set up their own centers. And good, let them do that. These are the avenues that we need to develop. People need to get out of the courts and go out to these forums. I'm not talking about mediation today, but that's another aspect. So it's mediation, it's arbitration. We need to open up these doors because we can't just bring in every case to court and think that we'll decide every matter. We cannot decide 2.4 billion cases. We need to take them out to mediation, take them out to arbitration. And with this new law, I'm very positive that things will totally change. So what we're looking in the future is towards a multi-door courthouse, and litigation is the last door to tap on. So people need to understand, and the mindset needs to change. कि हर चीज अदालत में नहीं लेकर चली जाना, हमने पहले और चीजें भी करनी है, हमने मीडिएशन भी करनी है, हमने आर्बिट्रेशन भी करनी है, और अगर वो फेल हो जाए तो फिर अदालत का दरवाजा खटखटाना है. यहाँ तो आप सारा दिन रात अदालत का ही दरवाजा खटखटाते रहते, ये नहीं होगा. Things will have to change. So the future, as I see it, and as we thinking about it at the court also, is to have ADR centers across 138 districts in Pakistan. When I say ADR centers which will have mediation facilities, then escalating on to domestic arbitration facilities also. And as you see, ADR laws आ चुके हैं पाकिस्तान में, उसमें अभी 1940 law का जिक्र आता है arbitration का. जब ये change हो जाएगा तो वो नई energy उन ADR के laws में भी आ जाएगी, because court interventions possible नहीं होगा. तो वो एक चीज हमें आगे की तरफ चलना है कि court annex to mediation leading to arbitration. ये मैं domestic scene की बात कर रहा हूँ, ये जरूरी होगा. दूसरी चीज जो बहुत जरूरी आगे चलने के लिए है वो ये होगा, और सारी दुनिया में है. In the entire world, we were in Doha and we saw 50 jurisdictions talk to us, and nobody was saying that the criminal law becomes, the criminal cases are important, or service laws are important, or family laws are important. Everywhere in the world, the top preference given to is commercial cases, because connected with the commercial cases is your economy. And connected with the economy is the well-being of the country itself and the progress of the country. So इसको समझें कि commercial courts को आपको बनाना पड़ेगा. हर करीबी जो हमारे साउथ एशिया की भी और बाहर भी commercial courts बन चुके हैं, हम पीछे रह गए हैं. मामले में पंजाब में कुछ बने, लेकिन हमें country wide commercial courts को लाना है. तो commercial courts की जब हम बात करते हैं तो उसके अंदर inbuilt है ADR system भी. So the hybrid commercial court that we're thinking of is a commercial court that talks about commercial arbitration within it, also commercial mediation within it, leading to, if there is a dispute that escalates into a court, is a commercial court. अब ये commercial court खाली नहीं चलेगा और खाली arbitration भी नहीं चल सकेगी अगर हम speed नहीं लाएंगे अदालतों में. देखिए कुछ matters तो अभी जिस तरह फैसल साहब ने भी कहा, awards को challenge भी हो सकते हैं कुछ, और कुछ वैसे भी लोग challenge करेंगे, rightly or wrongly. But they'll come to court. So sooner or later, somebody will be knocking the doors. Even though we have the state-of-the-art arbitration law, people will still knock the courts and say, knock the door of the courts and say that we are here. देखें चाहे frivolity case हो, आएंगे जरूर. इसी तरह हमें ये अब देखना है कि अगर हम नीचे अगर फैसला कर भी दें ट्रायल कोर्ट के लेवल पे, डिस्ट्रिक्ट कोर्ट के लेवल पे, तो हाई कोर्ट पे आके अगर उसमें 10 साल रुकना है, मखदूम साहब ने टाइसी का केस का जिक्र किया, 11 साल या 12 साल सुप्रीम कोर्ट में पड़ा रहा, तो फिर ये नीचे सारी चीजें करने का तो कोई फायदा नहीं. इस नए आर्बिट्रेशन लॉ बनाने का भी कोई फायदा नहीं अगर सारी चीजें रुक जानी है अदालतों में आके दोबारा. तो इसलिए अगर इस आर्बिट्रेशन लॉ को या मीडिएशन की जो हम बातें करते हैं, मीडिएशन तो चलो सेटल हो गया, आर्बिट्रेशन के कॉन्टेक्स्ट में अगर आगे चीजें आनी है तो यू नीड टू हैव अ फास्ट ट्रैक कोर्ट, जिसके लिए जिक्र पहले भी हुआ, कमर्शियल कॉरिडोर अगर नहीं हम बना सकते पाकिस्तान में तो फिर ये सारी चीजें नहीं चलेंगी. क्योंकि डिस्ट्रिक्ट जज अगर अवार्ड पे फैसला भी कर देगा तो आके हाई कोर्ट में अगले 5-10 साल के लिए रुक जाएगा और फिर 10 साल के लिए सुप्रीम कोर्ट में रुक जाएगा, तो सारा कानून बनाने का कोई फायदा नहीं हुआ. इसलिए I think the future vision is, and we're thinking on these lines, and I think the government needs to consider that also, there has to be a commercial corridor so that we have a commercial court, we have a commercial division at the high court which has a time frame working. उसमें family case और land और preemption के case नहीं चलेंगे, उसमें सिर्फ commercial court के case, commercial matters चलेंगे. इसी तरह at the Supreme Court we need to think of having a commercial division which will cater to this. And considering the state of our economy, as pointed out also, I think it is high time that we start put this focus on attending to commercial matters very seriously. अब उसमें टैक्स भी आता है, उसमें बैंकिंग भी आता है, उसमें बिजनेसेस की अपनी प्राइवेट ट्रांजैक्शंस भी आती हैं, ये सारी चीजें अलहदा करनी पड़ेंगी और फास्ट ट्रैक पे चलाना पड़ेगा. So basically, what I'm trying to say is that the arbitration law alone will not work unless and until we have a speedier court system that sort of blends with it. Otherwise, ये अकेला नहीं कर सकेगा काम अपना. और कोशिश ये है कि कमर्शियल कॉरिडोर डेवलप हो और इन चीजों को हम आगे ले जाएं, कमर्शियल कोर्ट्स बनाएं, एडीआर सेंटर्स बनाएं और लोगों को ये बताएं कि देखें सिर्फ अदालत आना नहीं है, ये और भी दरवाजे हैं जो आपको जिसको रिव्यू कर सकते हैं आप. जिसके लिए हमारे लिए बहुत जरूरी होगा, ये पहले भी बात हुई है, ट्रेनिंग का. तो ये मैं आपको बताऊं तो बड़ा खुशाई बात ये है कि एफजीए ऑलरेडी रन्स these programs here and they are already training judges who are coming for training on mediation and on arbitration, and now they will train them under this new law. We at the Supreme Court, we at the High Court level also have to understand this new law. There will be new jurisprudence that will fashion, which is fine. It will take time and it will evolve. लेकिन अगर जल्दी हो, अगर 10-20 साल लग गए इसकी evolution में तो फिर problem उधर का उधर ही रह जाएगा. इसलिए maybe the commercial division of the high courts will work. And the legal community has to also understand, and I request the lawyers sitting here also, and I keep hammering that point कि हमारी जो अदालतें स्लो चल रही हैं, कुछ हमारे भी मसाइल होंगे, कुछ रश भी है, कुछ काम भी ज्यादा है, पर कुछ आप लोग भी हैं. 80% एडजर्नमेंट्स के ही वजह से लेट हो जाता है काम. तो इसलिए इस चीज को भी देखें, स्ट्राइक्स के बारे में भी ख्याल करें जरा. अगर ये सारा हम निजाम चेंज करने लगे हैं और तेजी लाना चाहते हैं चीजों में, तो फिर आपका रोल भी बीच में आएगा. और फिर फ्रैंकली मैं आपसे शेयर कर रहा हूँ बात कि वर्ल्ड बैंक की रिपोर्ट के मुताबिक 80% एडजर्नमेंट की वजह से डिलेज हैं. तो वो उसको देख लें कि ये आगे नहीं चल सकेगा सिलसिला डिलेज का, आपको इनको चेंज करना पड़ेगा. और दूसरी बात ये होगी कि जो स्ट्राइक्स का कल्चर आपने एक बनाया हुआ है, दोपहर को कर लीजिएगा, शाम को कर लें किसी वक्त जाके, अदालत के टाइम में तो गुजारिश ना करें, वरना ये सारी चीजें फेल हो जाए. आपने टीवी के सामने जाना है, शाम को चले जाएं, तो हर वक्त होते हैं, चैनल्स चलते हैं, आप कर सकते हैं. You don't have to do it during the court hours. So इसके अलावा जो एक और चीज आपके साथ शेयर करना चाह रहे हैं कि अदर देन ये एवेन्यूज जो हम बना रहे हैं, मीडिएशन, आर्बिट्रेशन के अलावा जो कोर्ट में केसेस कुछ ऐसे होंगे जो कोर्ट में ही चलेंगे, उनका कोई तरीका और नहीं हो सकता. उसके लिए हम टेक्नोलॉजी लाने की कोशिश कर रहे हैं, एंड वी टेकिंग द टेक्नोलॉजी डाउन टू द सिविल कोर्ट, डूइंग अ लॉट ऑफ थिंग्स कि अगर हम उसको इम्प्रूव कर सकें, डैशबोर्ड्स वगैरह वगैरह. उसका आज दिन नहीं है बात करने का, लेकिन टेक्नोलॉजी का सहारा लेना पड़ेगा. हम वो कॉलोनियल स्टाइल पे और रजिस्टर्स उन पे नहीं चल सकते. काफी काम हुआ है लाहौर में भी, जैसे सुजात में यहाँ बैठे उन्होंने भी चीजें की हैं. इस तरह की चीजें हमने आगे लानी है और करनी है. So anyway, I once again, you see, I want to thank, and I think I missed out 2 other members of the committee who are from the government. एक कैशोर रहमान साहब बैठे हुए हैं, एक अम्बरीन थी, अब्बासी हमारे साथ, उनका भी बहुत शुक्रिया. Once again, I want to thank the committee and the members of the committee who did the real work. And now could I request the members of the committee to please come on the stage.